My lord, I'm paying for listing of this matter, my lord. Matter relates to, my lord, the private respondent has been appointed in our place, my lord. She applied for a medical leave and medical leave was not considered.
This is not a
Appointed
bench.
the
This is not a bench. That's not a bench for me.
bench three, no. It is my lord bench four matter.
No,
Anganwadi
no.
worker.
Huh? No, no. Agarwadi, no.
Bench three.
Bench three, bench three. Not a bench for me.
Public.
May I please, your lordship?
Yes.
Lordship, item number 7, we have filed one affidavit in opposition. May that be called for your lordship?
Item 7.
Yes, your lordship.
Public. In that case, item 7, lordship.
Huh.
But since they have filed the affidavit, I will file a counter, lordship. So another.
Wait a minute. Wait a minute. One at a time. Let us see.
My lord. Item number 22, my lord.
Yes.
The matter is infectious.
Okay, Mr.
A.M. Ahmed.
A. Mohammed, the process for the petition submits that the matter has become infected. Accordingly, the petition is dismissed as infected.
May I please, your lordship? Lordship, I beg to mention 3 items for motion on Monday.
Too many matters.
Tender matter, lordship, there is a, we have tender matter, lordship, wherein we are participating in a transportation bit and they will fix the LOA, everything will be given. Monday, there's a.
When will it be given? When is it? When was it open?
The tender was opening on 27th of February, but on 4th only we came to know, and till date they have not intimated our rejection. And it's a regarding
Is the technical bid open? Financial bid? Financial bid open?
This is a transport matter where financial bid is already opened of other bidders. There are 376 trucks which are sought to be taken by the IOCL. So my financial bid was, my technical bid was rejected on the ground that I had not given the RC. Whereas on the earlier tender notice on the same RC documents, I was given the work order.
So,
same RC doc, same vehicle, it's still running.
okay,
And
let us see.
Monday, deeply obliged.
Maybe the lordship. Madam, as per the instruction of my friend, madam, Mr. Kyle, madam, in item number 3, he has prayed for the matter for the also for the timing. So may I request this matter be taken on Tuesday, madam, on 19th, if your lordship cannot, madam.
They are there also.
Mr. Kyle had informed me that to take time.
Okay, right. On the prayer, on the prayer made on behalf of Mr. S. C. Kayal, Deputy SGI. It's your prayer or whose prayer?
Madam, I'm going outside Guwahati today, madam.
Huh?
Madam, I'm going outside Guwahati today. So, madam, this matter will be on Tuesday, madam.
On the prayer for adjournment made by Mr.
SP, madam.
S. P. Das. This is the matter,
19, madam.
not 19.
Madam, any hearing day, madam. It will take some time, madam.
24.
Hearing day, no? Hearing day.
May it please your lordship, item number 23, my lord. With due consent taking from the other side, my lord, I need further 2 weeks time to file my affidavit, my lord.
You're for whom?
I am for the respondent, my lord, Soil Conservation Department.
Miss, what is
RS
it?
Deori, my lord.
RS Deori is granted 2 weeks time to file affidavit.
May I please,
This
your lordship?
is the matter after 2 weeks.
Lordship, I beg to mention item number 6, your lordship.
Yes.
Matter may be taken up after 2 weeks, your lordship.
Why?
Lordship, I am on behalf of MS Roy. Due to some personal difficulties, lordship, I am seeking adjournment, your lordship.
Item 6.
Yes, your lordship.
Just a minute. Wait. Just wait. Yes.
Please, your lordship. Lordship, I beg to mention for listing, lordship, one last was listed on
Huh?
11/9/2023, lordship, pending matter.
Never date. Something.
Deeply obliged.
May please, your lordship. Lordship mentioning for the listing of a matter, your lordship, listing of a matter, lordship, lordship, it's a non-payment of bill, lordship, and since lordship, 2 years, lordship, my bills were not been payment.
When it relates to which year?
Lordship, the bills were of 2021, your lordship.
21. And when did you file your case?
Lordship, 2022, because there were some.
Why? You could have gotten there was no delay.
No, there was some
No
development.
hurry, no hurry. You give some date after April.
Lordship, in the first week of April, I am praying, your lordship. Much obliged.
May I please, your lordship? I beg to mention item number 26, lordship.
Yes.
Concern of the other side, the engaged council, AVD of So this is not for
Huh?
difficulty. Letter maybe I don't.
We have put the respondent six, Lord. We have not.
On the prayer for adjournment made by, on behalf of Mr. ABT Hawk, list the matter after a month. Any stay order? No stay order. After a month.
Lordship, my matter is listed today, serial item number 27 and 28. Along with the IA, my purpose of filing IA because I want to file reply affidavit against the counter affidavit 4185. So I may be given 7 days time to file the counter.
You want to file a reply, Lordship.
You have to file reply.
Lordship,
for it.
initially what happened, Lordship, he in the before he said, Lordship, he is not filing any reply. Now he's no problem, Lordship. He's not filing.
The petitioner in person is granted, how much time?
7 days.
Is granted 2 weeks time
Lordship.
to file affidavit in reply. List the matter after 2 weeks.
Oblige.
May please. I may be allowed to withdraw this with liberty, my.
Mr.
R. Sharma.
R. Sharma, learned counsel for the petitioner. Says that he may be allowed to withdraw the writ petition with liberty to file a fresh. Prayers allowed, this is the matter, prayers allowed, writ petition dismissed has withdrawn, comma, with liberty of speech. Highly up. No one appears for the petition on call. This is the matter after 2 weeks. No one appears for the petition on call. This is the matter after 2 weeks. Same.
PTC was supposed to put the inspection by.
Then. You came to the next.
Item 6.
No one appears for the petition on call. This is the matter after 2 weeks.
Item 7.
Actually, this just excise department has filed an affidavit today and I have received just the only. So I may be allowed to reply to the same person. Let me come up next week, Lordship, on Friday.
No, I'm not, I'm,
Call for the affidavit, can be taken out for some time, Lordship. You have called for the affidavit. Your Lordship.
okay. This is, his technical bit was disqualified
Yes, sir. Yes, sir.
after some time.
Very well.
You see, even if we allow you, I'm going to issue notice and do it. Otherwise, I'm not going to keep it in the motion column.
Okay.
Either I dispose it off or I issue notice, that's it.
Oblige, Lord.
Item 8.
In spite of the.
Just a minute. Yes, what is your case?
Well, in spite of the Sonarpur court's order, my lord, your lordship may kindly see page 54, paragraph 4 of the order.
Page 54. Page 54, yes,
The learned counsel appearing on behalf of the Health and Family Welfare Department submitted.
just a minute, The yes,
My lord, by this order, my lord, the authorities were directed to issue tender, fresh tender. But the authorities now,
by this order, what?
the earlier cases.
Just a minute. You're saying, come here, the learned counsel appearing, then we start off
Matlab,
with
that-
you.
that-
Please, if you're going to read it. If you're not going to read, don't read. Let me read.
paragraph 5. is
Yes,
the
what does it say?
In that view of the matter, the respondent authorities proposes to cancel the earlier tender wherein rejection of the petitioners on technical bid was the subject matter of the dispute. Nothing survives in the instant petition. The court, in view of specific instructions so received as quoted here and above, grants the liberty to.
So fresh tender has to be issued by
Yes,
the.
madam.
Yes, so
But, but till now, no tender has been, notice has been issued.
so
And 4-5 years that Malad, the earlier contractors were supplying by the end of this situation, Malad, they are continuing Malad without any tender. And this is the directly violates the procurement.
why don't you file a contempt?
Malad, at this stage, I am not facing any interim or for interim order.
What right of yours has been
Only just,
violated? What right of yours has been violated, Mr. Council? This is not a PIL.
Malad, I am also a contractor, Malad.
Huh?
And
Maybe all is supposing all the contractors in the world say, come to the court and say,
now the earlier government decided to call the tender centrally, well, as per the procurement act. But now the phase decision has been made to make it district level. And the district level authorities are, well, writing to the director that they have no infrastructure for the e-tender. That is the situation at present. So if it goes in this way, Malad, it will be
you are challenging this letter dated 17/1/24. Where is this?
Page 59, Malad.
Where? There's, yes, but
Madam, here I will have to see instruction, madam. Otherwise, my lordship will see from this particular impugn order
Ah.
that they are, my lord, challenging here. It's a discussion is on, madam. And my lord, from
Madam,
21, the matter was, my lord, pending before this honorable court till, my lord, May 2023. Thereafter it came up. Tender has already, my lord, been 2021. It has, my lord, already lapsed. So we said that we'll go for fresh tender.
yes, no, he wants a fresh tender. I think.
Yes.
Yes, I
I will have
also
the
want.
instruction when they are going to.
Malad,
But, my lord,
policy that has been changed, Malad, at district level.
there, my lord,
tenders.
how can he, my lord,
Malad,
claim that it should be?
Your lordship may
as
kindly
per
see
his
these
terms?
letters, Malad.
What do you want? You want that the policy that is going to be changed should not be changed.
Yes, Malad.
What is your right?
Malad, my
What-
right, Malad,
No right. Sorry.
my right, Malad, your lordship may kindly.
Sure, sorry. No right.
Where is this letter, Malad?
Show me the law under which you can challenge.
Malad, the procurement act says, Malad, the job tender, Malad, how long they will continue, Malad, the tender is.
That is a different issue.
Malad, as per the decision.
Mr.
Malad,
Council, please here.
there is
Don't get
violation.
excited. Don't get
Yeah,
excited.
yes.
You see, the thing is, what are you challenging here? You are challenging the letter dated 17/1/2024.
Yes.
Correct?
Yes.
Now, what does 17/1/2024 say?
Malad,
What does it say?
it says, Malad, that at district level, the tender should be called, Malad.
At the
And-
district level, tender should be called. Then, so what is wrong?
Malad, the position of the district level, your lordship may kindly tell us the three
Aye.
letters, Malad.
Huh?
The district authorities, how they are, what they are saying, Malad, your lordship may tell.
That is between the government, that's the government.
Malad, the procurement act says, Malad, there must be transparency and fairness, Malad.
So they will,
And some selected persons are going on, Malad.
okay, that's all, then, that's all, that's your case. This is,
At this stage, Malad,
at this stage, there's no stage. At this stage, I'm dismissing. You can go to the division bench. You're challenging a policy decision of the state.
at least it's a public, state largest, Malad, for distribution of state largest.
So you
must
see,
be
if-
tender system, Malad.
You see, Mr. Council, it's not that they are going to,
Malad,
not- please understand, please hear me. It's not that they have said that they will not do it by way of tender. They said that they will do it by tender, but then it will be through the district.
Malad, at district level, the authorities are saying, Malad, that there is no infrastructure for e-tender. And if there is no
That
infrastructure.
is for them to,
Malad,
huh?
yes,
Between the departments.
between the department, I agree, Malad, but in the meantime.
You join politics or you join the Assam civil service
Malad,
or that whatever service, and then you tell them how
I am
to do it.
maintaining my profession as a contractor.
As a lawyer or as the counsel for the contractor, you cannot say how the tender should be floated. That is not your job.
Consequently, my lord, there is the monopolization of those persons who are supplying, my lord. That is, for that reason I have come, my lord.
Then you file a PIL, public interest litigation. This is,
My lord, Procurement Act that has been violated, my lord.
why, which part has been violated? Tell me.
Section 4, my lord, fairness of
Sure.
the,
Where is the fairness? Where is the tender?
my lord, if tenders, my lord, if district authority says, my lord, they don't have any infrastructure, how long it will continue, my lord?
No, they will file, yeah, why don't you issue the tender, that's all. But you cannot challenge the method that
No,
tender
he
will
is
take
kind
place.
of doing the brief of the district authorities, it seems, my lord.
Huh?
He is speaking for the district authorities against the government, no.
No.
It's up to
That
the.
is,
he-
I am not telling
correspondent,
about, my submission is not like this, my lord. Tender that should
No,
be.
no,
made-
it should be floated by whom, according to you?
Tender may be made, my lord, at district level, my lord, as per this decision, but at present, the authorities are, of the government itself saying, my lord, that they don't have infrastructure, and consequently, it will delay the tender. So it should be called by called centrally by the director level, my lord. That is my suggestion. I am not against the issuance of tender, my lord. I am not against.
Then why have you challenged in your writ petition? Why have you challenged page
My lord,
59?
this has been challenged, my lord, because of that, my lord, they are not having infrastructure, this decision will affect me, my lord, at present, my lord.
Okay, I'm dismissing your writ petition. No case. You go to the division bench. Heard. Mr. D. Chaudhary. Learned counsel for the petitioner. Who submits. That
Sir,
he,
My lord, I will facilitate, my lord, I may do one thing, my lord, I will file a representation, my lord, that may be accommodated.
you file a representation.
Oh, your lordship may observe on this point.
but that part may not be observed again,
Part.
he will take the view of this representation and all. Government
Yes.
is doing the job, they will do. It's not that, my lord, we are.
I am not against it.
You file a PIL, Mr. Counsel.
Yes.
If you are so,
At the, in
you
this-
cannot challenge a policy decision just because you are a contractor and you say that director should issue the tender, not the district level. Who are you to say that?
I am
Even
nobody, I am nobody, I know
When
my.
this High Court cannot do it, who are you to say it?
I am nobody, I know, my lord. I have challenged only because of the fact, my lord, consequently, it will delay the entire process, my lord, and.
That is a different issue. But then the manner in which you have gone about it is wrong. The manner in which you have gone about your writ petition is
I
wrong.
will allowed to file a representation, my lord, your lordship may observe on this issue, my lord. The government will consider my grievance, my lord.
What right of yours has been violated? Why should we just give them job just for your satisfaction? Why should I give you?
Only, my lord,
What I can do is you can withdraw and find a better petition, not in the manner you have done. This is challenging a decision which a Supreme Court also cannot do.
Yes, I will be allowed to do it liberty.
Mr. D. Chaudhary, learned counsel for the petitioner, says that he may be allowed to withdraw the writ petition with liberty to file afresh. Mr. B. Gogoi appears for the Health Department. Where the petition counsel is allowed, with petition dismissed as withdrawn, with liberty of faith.
Good night.
Yes, madam.
Instruction is clear.
What instruction?
My lord, today it has come for the first time, my lord, so.
Yes, what instruction will you take?
My lord, the prayer, my lord.
His only prayer is that his appeal should be disposed of. Correct?
Yes, if my lord, that is enough for us prayer.
So if it's not this,
In the meantime, lordship impugn to order may be stayed.
no.
That is my lord.
Lordship kindly have a look at the page 26.
Page 26.
Lordship.
This is the representation submitted by the petitioner in response to the proposed notice. Lordship, kindly have a look at para 1. Lordship, PDS item is to be distributed in 9 to 15th of each month, Lordship. Before that, it was seized on 8. And that aspect was not considered while passing the.
Oh, no, we
That
see,
is not-
right. When was your license cancelled?
Lordship, that is at page 33. Page 30.
Yes,
May I read?
6 November 23. There's no question of stay now.
And my lord, it is there that
Already 4 months have gone.
sufficient intermediate material are on the records
Ah,
and five.
correct.
There are my materials are there, my lord, so that's why my.
Where is your appeal?
Lordship, that is at page 42, Lordship.
Appeal dated
It is dated, Lordship, 19/2,
19/2.
Lordship.
After my lord, about
Yes,
uh,
after,
3 months.
after,
Lordship, before
after
that
2.5
also
months.
submitted, Lordship, that is also there. Lordship, kindly have a look at page 34.
No, I'm not on that. Appeal is, then another appeal.
Lordship, two appeal,
Same date,
two petitioner,
two petitioners.
Lordship, two petitioner and they made two appeal before the authority. That is till date. It was
Mr. Council, cause of action is different,
no
same.
Lordship,
same cause of action,
Lordship,
huh?
same. And imprint order also same, Lordship.
Correct. Heard Mr. L.R. Mazumdar, learned counsel for the petitioner who submits that the petitioners are fair price shop retailers whose licenses have been cancelled by the impugned order dated 6/11/2023. Though the petitioners have submitted their appeals to the District Commissioner Kachar Silchar on 19/2/2024, no decision has been taken on the same till date. So then what to do? We direct them to take, that's all, end of the matter.
But
We told this,
my lord, no stay.
no say, no.
Lordship.
There's no question of stay.
Deep left.
Full stop. There's no question of stay. Full stop. Miss U Das, learned counsel appearing for
All the
all the respondents submits that the matter can be closed if the direction is issued to the District Commissioner Kachar Silchar to dispose of the appeals within a specified time period. Full stop. On considering the fact that the petitioner's appeals have not been disposed of till date, the District Commissioner Kachar Silchar is directed to dispose of the appeals of the petitioners by way of a speaking order within a period of
3 weeks.
3 weeks, within a period of 4 weeks from the date of receipt of a certified copy of the order.
Lordship.
That is petition accordingly disposed of.
All right.
I am appearing for the respondent.
What is to be done?
Notice may be issued, my lord.
This for what?
For motion hearing. The petitioner's claim for the damages charges which was levied against him,
Okay, right.
and also the challenge the speaking out.
No one appears for the petitioner on call. The matter pertains to No, the grievance of the petitioner is with regard to number one, deduction of rupees 8,99,130 from the refundable security money. Number two, recovery of demurrage charges totaling 30,77,366. Number three, no, full stop. Besides the above, the petitioner also paid for setting aside the impugned speaking order dated 16/6/2023, wherein his claims have been rejected.
My submission is that with regard to the damages charges, the petition is not maintainable. My lord, kindly see page 6.
And what about the other part?
There I will take instructions back. But with regard to the damages charges, the petition is not maintainable since he has submitted no demand certificate.
Full stop. Issue notice returnable in 4 weeks. Mr.
BKC,
BK Singh appears for the railways,
no, FCI response.
FCI. He submits that the writ petition is not maintainable in respect of the demurrage charges claimed by the petitioner. Now, in respect of the recovery of demurrage charges claimed by the petitioner, in view of the fact that, in view of,
Yes, he has submitted no demand certificate.
in view of the fact that the petitioner has not submitted any, invert
He
comma,
has
no
submitted the
demand,
no demand certificate against the concluded contract.
in as much as he has not submitted
He has
no,
submitted, madam, no demand certificate, means he has no demand against the FCI, madam.
okay, in as much as he has submitted no demand certificate against the concluded contract. What about the full stop? What about the refundable security money?
That way I will take instructions.
Full stop. He submits that he will obtain instructions with regard to the deduction of the refundable security money. This is the matter after 4 weeks.
All right. Extra copies may be served.
You tell him, I don't see him.
All right.
This matter relates to my lord, grant of the my lord IMFL license.
Huh?
Grant of my lord IMFL my lord off license by my lord e-tendering process.
Lordship Council, KP Pathak is on legs. He shall be appearing for respondent, Excise Department. Matter may be taken up after some.
What is the matter about?
My lord, the
Of license given to the respondent number 5.
respondent number 5, my lord, that it's my lord
Your case is what?
twofold bit, my lord. First is the technical and second is the financial, my lord. The technical bit, I have also, my lord,
You have also responsive.
responsive and the private respondent number 5 also, my lord, declared to be responsive. But I have objected to that because the mandatory conditions, those were not fulfilled by him. My lord, immediately, my lord, I have submitted representation before the, my lord, of-
That is for them to say, not for you.
No, my lord, that is one of.
You can object, but it's their power, government power.
My lord,
They can deviate even from a essential condition.
Yes.
Then-
Yes, it is eligibility.
So
condition.
let us see what they say.
It is an eligibility condition
Whatever.
for submitting that.
Let us- But he's not here.
One of the aviator, appearing.
Caveat is not the government. What is he going to say?
Side department will give the reply.
Yes, he's only going to support.
What time?
Is involved in this revision.
Huh?
Please, your lordship, consider matters pertaining to restoration of electricity connection, lordship. In this matter, lordship, the respondent authority have disconnect my electricity connection without assigning any reason, lordship, without issuing any notice.
Yes,
No, it's not because of any motive. No, it was based on a complaint filed by the owner of the premises.
but who is in possession?
That we do not know. He's not even
Lordship, I am
included
in
that
the
party.
party,
my lord.
He's not pleading the party. Oh,
Lordship, I am in the possession, lordship.
We cannot possibly ascertain that.
Lordship, I am in the possession of this land, lordship.
Mr. Counsel,
Yes, lordship.
It has been, your electricity connection has been deducted, has been disconnected due to a complaint made by,
One Savinderjeet Singh Sethi, my lords, at page 27.
page 27.
Yes, Lordship, that was informed after giving my representation, Lordship.
You make him a party. You make him a party,
Yes.
and then we will consider your petition. Hey, look, the law is clear. The only thing is that the authorities, the PDCL authorities have to see whether you're in possession of that property or not. Then temporary connection has to be given to you. Only problem is whether you're in possession or not. Okay, that they will look into it. But there are other aspects. It has been disconnected. The electricity has been disconnected because of this SS Sethi
Yes, Lordship.
complaint.
Okay.
You have not made him a party.
Yes, Lordship.
You made him a party.
Lordship, page 24, Lordship, thereafter, 145 proceeding is going on. Thereafter, we have filed this petition before the honorable court.
Mr. Council, did
Yes,
you
Lordship. Sorry,
understand?
Lordship.
So, you can file application for implement of that so. Or you, I don't know, whatever. I don't feel like saying it, but then it'll be easier for you if you withdraw and file with that person as a party. It'll take less time.
Yes, Lordship.
Otherwise, you're going to file application, I have allowed, then you're going to file amended petition.
Lordship, I will withdraw and file fresh. Lordship.
Please give all your facts out here also, huh? Don't hide anything. Mr. Mr.
PJ Datta.
P.J. Datta. Let him counsel for the petitioner, please that he may be allowed to withdraw the petition. Come on with liberty to file afresh. Mr.
B. Chaudhary.
B. Chaudhary appears for the APDCL. Prayers allowed, with petition is dismissed as withdrawn, come on with liberty appears for.
Obliged.
That is Lordship. Matter related to not payment of bills, my lord.
Bills.
Yes, my lord.
Why, this is a money shoot or something?
No, my lord, no.
Then why have you come here?
My lord, can you see the 55 page or 55 laser? My lord, we have supplied, my lord,
Since when have you supplied?
my lord, we have supplied from 2018, my lord.
2018, and you suddenly
No,
come
no,
here.
no, my lord.
Huh?
Kindly say page number 55, my lord. Laser.
55.
And except 3, my lord. And it started from a COVID period, my lord, 17/6/2020 to 18/6/2021. We have supplied the raw materials, my lord. And at this statement, notice may be issued, my lord.
Why?
Against the response number 4 and 5.
Why?
My lord.
Why shouldn't you go to the civil court?
No, my lord, section, my lord, they have not paid, my lord.
So? Money recovery suit has to be filed where? High Court.
No, my lord.
Then?
Well-
Yes.
So I appear for response number 1, Your Lordship. Otherwise, Your Lordship, the jute mill is come under the register cooperative society. And it's a registered society. Now, whether the writ petition is maintainable or not, that is the issue, Your Lordship. Because they ought to have filed a money suit claiming their dues, Your Lordship.
My lord,
But-
kindly see the page, page
The
number 7.
problem is that the Limitation Act will bar them now.
My lord. My poor person, my lord, who is about 72 years, as per their request, my lord, they supplied.
Take it easy, take it easy. You give you an inch, you're taking a foot. Yes, that's correct. What's your name?
R. Hazarika, my lord.
Mr. R. Hazarika, learned counsel for the petitioner submits that the petitioner has not been paid his supply bill of rupees 21,54,352 for supply of raw jute, for raw jute. To
Response number 4 and 5.
respond number 4 and 5. Issue notice returnable in 4 weeks. Mr.
G. Bodkin.
Accept notice on behalf of
Response number 1.
1. While, huh? You thus accept notice on behalf of response number 2. Mr. Who submits the P Nayak, accept notice on behalf of response number 3. This is Assam Cooperative Jute Mills Limited. What is this? This is a government of Assam undertaking. He's a private individual or what?
Cooperative society. It's a cooperative society registered under the, some cooperative societies at 2007.
Fund were contributed by the government, state government and the central government. Revival project also sanctioned by the central government.
Okay, issue notice, I mean, the petitioner will take steps for service of notice upon the respondents number
456.
456 by a registered post which any within 3 days, leaves the matter after 4 weeks. What time?
44 also.
Huh?
44 also similar matter.
44 also similar matter, except,
Amount 18 lakhs,
18 lakhs,
60,349.
60,000, 349.
Fine.
Item 44,
Yes, madam.
okay.
Deeply applied.
Item 7. Item 7.
Okay.
In this matter, since a statement was made by the petitioner that he had submitted his APDCL bills, I asked the department to re-verify also. We have filed an affidavit that even for other bidders who have submitted their bills, we have considered, but he did not submit anything regarding that.
He did not submit any electrical,
No
electric.
certificate.
Lordship, their physical documents are also kept, Lordship.
Huh?
Along with the e-documents. E-documents, they are manually, they also used to keep a set of documents, Lordship. That is also verified when considered for evaluation, Lordship. In that document, that is there.
E-document is there.
No, in that electricity bill is there.
It is a
Yes,
e-bid system.
Lordship.
So in the e-documents, that electricity
That was
bill is there.
due to their fault, Lordship. They suddenly stopped the e-bid system at 3 PM, Lordship. And then again open at 4. Lordship. Then they did not publish that extended period, Lordship. When it was extended from 17 to 18, that was supposed to be published online, Lordship.
Where have you said that in your writ petition?
Yes, I have read it, Lordship. At page 9, Lordship, paragraph 8. Married, Lordship. At paragraph 8, Lordship.
Yes.
That the petitioner said that if the closing date for submission of the EPD is to be extended for any reasons, the district collector now ought to have circulated the same online in the said website. Non-communication and non-uploading of the any reason for extending the last date of submission of the EPD makes an the intention on the part of the responding authority.
No, Mr. Counsel, this is different. This is with regard to the date of, the last date of submission
Yes.
being extended by 1 day.
Yes.
From 17 to 18. You were, what you just said now was that from 3 o'clock to 4 o'clock, you could not submit because the portal was closed. Where have you said that 3 to 4 o'clock it was closed?
But that has not been mentioned, Lordship. But Lordship,
So so first think before you say something.
that is not further instruction, Lordship.
Further instruction, when? You further instruction today,
No, Lordship, after the case was listed.
after the
first
case
time-
was filed.
listed for the first time.
You see, Mr. Counsel, all your submissions were recorded on the last day.
Lordship.
The 3 o'clock to 4 o'clock was never a part of it. Neither is it there in your writ petition also.
Lordship, but in the last order, Lordship, they have stated that on 6/3/2024, your Lordship order at page 3, Lordship,
Yes,
paragraph 4.
yes.
Mr. K. Pathap, KP Pathap, Learned Counsel for the exercise order and submits that the extension of the last date of submission of documents in the terms of NIV from 17/1 to 18/1 had been done by the Superintendent of Excise after due approval had been taken from the concerned deputy district collector. In this regard, he has submitted letter number 20/60/2024. Lordship, already it was on 17/1 and the letter is of 6/2024, Lordship. And that was not uploaded in time, Lordship. They were supposed to be uploaded on the same day.
That letter
When
was
it was
addressed to me,
extended,
that
Lord.
was an instruction letter.
That's what, that letter has been addressed to him, the council.
So it is written like that, Lordship. And moreover, Lordship, in the act, Lordship, your Lordship may kindly
peruse section 23. I have provided the copy of that.
No, the issue is very simple. The issue is this, what they are saying is that you have not submitted your no dues electricity certificate.
This was in the record also.
Now,
If
you are, they are saying no, you are saying yes. Now, what am I to do?
So see, if the physical documents are brought, record is produced of it, then it can be clear of it.
But this is an online bid system.
Yes, online,
Only if
online,
there's a discrepancy between the online and physical will be seen. But
because
if we do that for him, it will be very unfair for the other bidders whom we have rejected. Many people might come and say it was there in the physical, online I did not upload.
But then if he did not, is it possible that if he did not submit that no dues electricity certificate, that his bid is still accepted by the porter?
No, the bid will be accepted. The portal will accept it. But while opening, while we scrutinize it, then we could not find it. Portal, even if anybody can, your lordship, make an account there and submit a bid. But if he does not submit the documents,
No, what I'm saying is, if he does not submit all the documents that are required of a NIT,
lordship.
it will still be accepted.
Yes, I believe so.
I believe so, will not
Because
have.
I cannot, because that is a very specific technical question. I cannot-
Yes, so that is what his case is all about.
Yes,
So you have to inform this court as to whether if
lordship, I can, after 5 minutes, I'll get the instructions over phone. That if that is possible, lordship, pass it over phone.
so this is a question of fact, Mr. Counsel.
but lordship, as per the act and the rules, they are supposed to do that. Online publication, that should be made public
Online publication of what?
of the origin number.
Mr. Counsel, I'm not on that. You are still on that. Leave that aside. Okay, so that aspect say we agree with you. 100% you are correct. Accepted. Now, second point is you did not submit the no dues electricity certificate.
That can be.
They are saying no. You are saying yes, you submitted. Now, how do we decide that you submitted?
Some measure false were considered was it.
Huh?
As per
Legal?
their report was it at page 65. The committee conducted a thorough checking of the documents uploaded by the bidders along with the application. Subsequently, verification of the proposed sites were also done. With regard to production of no dues application service, some bidders have submitted in their own names, while some others have submitted in the names of their respective landlord, parents, or relatives. In respect of age group of documents submitted by Harbhajan Singh, it is in that date of birth in PAN and Aadhaar card is so and so, SLC so and so, date of birth is different. And that,
Mr. Counsel, I'm not on that. Please don't go into those other issues. I just want to know one thing. How does this court decide whether what you are saying is correct or whether what he's saying is correct? Do I take the decision on the basis of who has got a better hairstyle, more hair, more handsome, more taller, what? On what basis should I say that? Because you have said that you submitted the no electricity dues certificate.
Yes.
They said that you have not submitted. Now, how will I decide that?
if that
That issue,
other documents are called for of it.
other document.
Yes.
But he says that
One
it is,
set is filed physically also.
can you, maybe in the pen drive or something? Since it's a e-bit system.
Otherwise, I have a copy of his e-bid.
Okay, e-bit copy.
If the document was not there, but in the physical documents,
Huh?
it is there.
E-bid,
But if the e-bit it was not there,
It is not there. Not,
oh,
not-
then end of the matter.
no lordship, for verification and evaluation, they taken into consider the other documents also.
Mr. Counsel, during the e-bid system, when you submitted your bid online,
Yes.
was that no due certificate a part of your tender document?
As per my instruction, it was submitted, lordship, but it could not be found here in the.
Well, now I'll see that. Then.
I have got instructions, your lordship, that once the application.
You
fees-
cannot,
I have submitted that document, lordship. Even the police verification was also ready on 17/1, lordship.
My hands are tied, Mr. Counsel. I have got, otherwise, you'll go to the civil court or some other court. I do not know how to decide this. Yes, somebody can help, Mr. Shaikia, PJ Shaikia. The documents are supposed to be submitted through online bidding. They are saying that he did not submit one particular document A. He says he submitted. Now, how do I decide whether he submitted or did not submit? Who do I decide is telling the truth?
So what I understood was he said he did not upload it in the online.
That's what I mean. I heard. Now he's saying no, he uploaded it. That's why he's changing his stance. That's the problem.
What he says, while physically verifying the documents, he has submitted the electricity.
Oh,
not been
then
taken
end of the matter.
But
Sorry.
two other documents.
So no, that's okay. So it means that he did not submit online. Unfortunately. Unfortunately. No, other point no need. One point is enough.
No, because they were supposed to upload that document also for corrigation. Then I could have got the opportunity.
They were supposed to upload, you are supposed to upload.
No, they were supposed to upload the corrigation.
That's for
Online.
extension of time, you mean?
Yes,
For the extension.
then I could have got the opportunity also.
No.
That was not made public also. And as per the act and rules,
Okay, give me the, I think I've heard enough. Mr. Counsel, sometimes you miss the bus. Buy a whisker. What to do? Okay, right. Heard Mr. D. Barwa, learned counsel for the petitioners. Also heard Mr. K.P. Pathak, learned counsel for the excise department. The petitioner's grievance is with regard to the license has been given already.
License has
the-
not been given. License has not been given.
Not been given. The petitioner's grievance is with regard to his technical bid being disqualified on the ground that the petitioner had not submitted proper police verification report, in terms of, no, in terms of clause 6.2.20 of the NIB and APDCL clearance certificate in terms of clause 6.2.18 of the NIB. Gustav. The further grievance of the petitioner is that the last date of submission of the tender in terms of the NIB was 17/1/2024, which had been extended to 18/1/24 by the superintendent of excise and not by the concerned deputy commissioner. Gustav. The facts of the case in brief is that the petitioner had applied for Indian made foreign liquor, bracket IMFL, a retail off license. In terms of the notice inviting e-bid dated 14/12/2023. Full stop. As stated in the foregoing paragraph, the petitioner's technical bid was disqualified on two grounds. And two grounds. That is non-submission of proper police verification report and APDCL clearance certificate. Full stop. Next paragraph. The petitioner's counsel submits that if the petitioner had been informed of the extension of the last date of submission of tender documents from 17/1/2024 to 18/1/2024, comma. The petitioner could have submitted the proper documents on the extended last date. Mr. A.P. Pathak, the learned counsel for the excise department, on the other hand, submits that the extension of the last date of submission of documents in terms of the NIB dated 17/1/2024 to 18/1/2024 had been done by the superintendent of excise, comma, after due approval had been taken from the concerned deputy commissioner,
District collector.
from the concerned district collector. In this regard, he has submitted letter number NXC 33/2023 2024 /PTI dated 6/3/2024, issued by the superintendent of excise and which is addressed to the counsel for the excise department, Mr. K.P. Pathak. Is it?
Mr. P. N. Goswami.
Huh?
Mr. P. N. Goswami.
P.N. Goswami, Mr. P.N. Goswami. Goswami. Next para. The petition, Mr. K.P. Pathak submits that on checking submits that the petitioner did not submit proper police verification report and he did not submit any inverted commas, no dues electricity certificate from the APDCL in terms of clause 6.2.20 and 6.2.18 of the NIB. Next slide. Acha, before that, the petitioner's counsel submits that though he did not submit the APDCL clearance certificate, comma, he had brought the he had brought his electricity bills which showed that he had paid all his electricity dues at the time of verification of the documents. Correct?
At the time of submission of the document.
At the time of submission of
Physical copy of the document.
physical copy of the document. Physical copy of the document. Next. So anyway, come back to this. I have heard the learned counsels for the parties. The submissions made by the counsel for the parties make it clear that the petitioner had not submitted he had not submitted his no due certificate. No
Or
dues.
any electricity bills.
They had not submitted any no dues, had not submitted any APDCL clearance certificate or any electricity bills showing that he had cleared all his electricity dues at the time of uploading his tender documents in terms of the NIB. Full stop. The respondents as such cannot be faulted for disqualifying the bid of the petitioner for not complying with clause 6.2.18 of the NIB. Full stop. Further, the subsequent the subsequent deposit of the physical documents does not in any way uh, correct the mistake made by the petitioner in not submitting his online bid with an online bid consisting of, no, with an online bid with the APDCL clearance certificate, comma, as the acceptance of the same is with as the question of acceptance of the same lies solely with the author of the tender documents. In view of the reasons stated above, comma, this court does not find any reason to exercise its discretionary power in view of the fact that no infirmity if no infirmity is made out in the state respondents disqualifying the petitioners with the writ petition is accordingly dismissed.
Timing 11.
Procurement rules, yes, sir. I don't know. Who is this? Yes,
But the bid document is at page 18. And lordship may come to page 26. Clause 2.
page 26, clause 2.
Clause 2.
Yes,
Overview of eligibility requirement for the participant in bidding. An individual, a partnership firm, a limited liability partnership, or a company registered under the Companies Act 1956 or subsequent enactment who has proof of filing income tax return for the 3 financial years out of the last 4 financial years and duly certified by the chartered accountant is eligible to participate in the bid. Now, lordship may come to page 32. What document need to be uploaded? Page 32.
yes,
My lord will come to clause 6. About 9th line, my lord. Copy of income tax return.
yes,
Copy of income tax return along with balance sheet for the year 2019 to 2020, 21, 21, 22, 22, 23 as 3 in sequence and statement of net worth as certified by the chartered accountant. So these 3 documents need to be certified by the chartered accountant. Now your lordship may come to page 75. The document he has uploaded. This is the page 75 is the return. This is not certified by the CA. Then next is the page 76 is the balance sheet. It is also not certified by the CA. All the 3 years return. But in this way, for all the 3 years return in the balance sheet are not certified by the CA. So far as net worth is concerned, my lord, that has been certified by the CA, my lord. And now, my lord, will find
net worth is certified.
net worth is certified. Is at page 82, my lord. Now, why it is required, your lordship will clearly see, my lord. The IT returns so far the individually are concerned, or my lord, they have a limit of 20 lakhs, and so my lord, till then, my lord, the self-assessment is my lord to be given, and while uploading the my lord, while filing the return, the balance sheet or other documents are not necessary. So therefore, my lord, this has been my lord, they have set as a my lord, essential documents, but with regard to the company, it has to be certified by the my lord, CS. If your lordship comes to page 34. So first, my lord, the company is concerned, this balance sheet is not required, my lord. Page 34, in case of bidder is a company.
Is he a company?
Individual, well, I'm just showing the distinction because
Ah.
that is the individual, this is the company. In, individual balance sheet is to be certified by the, CA. But so far as company is concerned, since it is already, filed, certified by the, CA, so, their balance is not required. The lordship will find, but however, it is required, third line, a copy of the latest audited financial statements such as the balance sheet and the proof of loss account. Is there, then your lordship may come, the bottom, Again, copy of income tax return for the year 2019-20, 2021, 2021-22, and 22-23, duly certified by the chartered accountant as well as those for the.
Where are you reading?
Hello?
Okay. Copy of income tax returns
That's it.
in the middle.
That's it. In the middle, copy of income tax. For the individual directors, as well as for the company, balance sheet is factor because the audited financial statement is already there, such as balance sheet statement. So that is an essential condition that they have, he did not fulfill.
Yes, but
And there's, apart from that also, will find the documents comprising is the page 32.
yes,
Lordship may come to page 33.
yes,
About 12th line,
yes.
copy of the document showing the bid right title in the process so income tax, sale tax, and professional tax clearance certificate, as the case may be. Now, here lordship will find page 84 is the professional tax he has paid. This is at page 84. Period from and to column, Fifth slide, will find period from and to 1/4/2022 to 31/3/2023. The tender was floated, they published on 29/11/2023, and the last date of bid submission was 28/12/2023. Now, your lordship may come to page 85. 12, payment of dues. The amount of tax due from enrolled person for each year specified in the certificate announcement shall be paid in respect of a person who is enrolled before the commencement of a year and is enrolled on or before 31st day August, before 30th day of September of that year. So the amount has to be paid by the 30th of.
Anyway, let me hear, yes. Tell me.
Lordship, just before addressing on merits.
Huh?
Before addressing on merits, there is just one issue here, Lordship. The petitioner here, he was aware of that this person has been technically qualified.
He's also technically qualified.
He was also technically qualified.
Correct.
So he waited for the financial bids to be open.
Huh?
Then after trying his luck there, then coming unsuccessful, then he has come before this.
Naturally, he has to wait for the financial bid to be open.
No,
No, because if he has a problem with the technical qualification.
He doesn't, technical
Well,
qualification.
technical bid was open on 22nd February.
Yes.
And my lord, I have submitted my representation on 23rd February. Price bid was open on 26/2/2024. It is incorrect, my lord. Apparently, my lord, I have given my representation.
Before coming to this court, he has come very late, Your Lordship. That's one aspect that
He was waiting for you all to do something. And as usual, you all are sleeping.
Otherwise, we have received instructions in this matter, Your Lordship. Regarding the requirement of income tax, Your Lordship, it is stated that clause 6 of the bid of.
No, what about those which required chartered accountant to sign?
Yes, regarding that IT returns, it's a system generated document, Your Lordship. So once the PAN number is there, anybody can check that record, Your Lordship. So even if that is not certified by the chartered accountant, but since it's a system generated document which is tamper proof, so we accepted it. The net worth certificate was signed by the chartered accountant. That's what it's saying, sir.
Net worth,
Yes.
but what about the balance sheet?
Balance sheet, requirement is
Anything-
only for the IT returns.
Huh?
Requirement was only for IT returns.
No. We come to page 32. The fourth paragraph from the bottom.
Copy of IT returns and statement of net worth has,
Along with balance sheets.
yes, IT returns and balance sheet and statement of net worth to be certified by the,
Yes,
the balance sheet perhaps we accepted it as it was.
we do not know. Perhaps, perhaps we'll not do.
No, your lordship, because in these instructions, it says that, because I am again bound by these, your lordship. It says that the copy,
So when was the license allotted?
the letter of,
That has not been issued, but LOA has been issued.
Yes, are you there?
License
Yeah.
not got.
LOA has been issued, you know.
LOA.
It has been issued, and we have deposited the 31 lakhs and all, the agreed amount, and the other matters are in process in the, you know, file.
Yes.
Okay, you file your affidavit, we'll see. Yes,
They are not taking two submissions basically.
correct.
One is that their income tax return along with the balance sheet not certified. So notice kindly come to page 32 again, I'll take my lord to cover. My lord, there is no requirement of the income tax certificate along with the balance sheet to be certified by the, my lord, chartered accountant. My lord will kindly see copy of income tax returns along with balance sheet for the year so and so, and your lordship will kindly see, and statement of net worth is certified by the chartered accountant. Because you know, net worth, what is the net worth? But I can't give a certificate. Ultimately, it is the chartered account who is the competent person will give. My lord, the income tax returns are my lord, already system generated. We have to give it online. I have given as it is what has been submitted.
What about
online.
balance sheets?
Balance sheet is not required. My lord. Balance sheet is not required to be submitted at all in the my lord, income tax return. My lord will
No,
kindly-
no, but then the department wants it.
My lord, the department asked me, lord, but the requirement to not submit a income tax return along with the balance sheet to be certified by the my lord, chartered accountant, that is not the requirement, that is my submission. My lord, the requirement is with regard to net worth to be certified by the chartered accountant. Your lordship will kindly see that aspect of the matter, my lord. And then, my lord, may I just point out to my lord, page 34. My lord, the distinction between the company and the private individual. Page 34.
Yes.
That same thing. My lord, it will be in the mid, copy of income tax returns for the 3 years. And duly certified by chartered accountant. My lord, your lordship will kindly see, my lord, under the law, companies are required, my lord, to my lord, do the audit, my lord. I am, as an individual, my lord, I am not required to do the audit. So, my lord, audit is not compulsory. So, if the audit is not there, the question of chartered accountant certifying, not certifying will not align. If your lordship kindly see page 75.
No, even if you are, it depends upon, I think, for the amount of turnover that you make. It's not that.
Turnover,
Correct,
rightly,
correct.
rightly, my lord. Your
So
lordship will kindly
you cannot
the-
take, you cannot say, you cannot say that.
No, audit is required. I am saying audit is required for an individual also. But it depends on the turnover. My lord, my turnover will kindly, lordship will kindly see. It pays 75. And if need be, my lord, I'll place the, my lord, income tax law on that ground, my lord. Let your lordship be taken the matter on, my lord, Tuesday, my lord. I'll place it.
No,
Because
not
so
so
far I am
short.
concerned.
Yeah, there are too many cases. This is not the only case in the Guwahati High Court. That's the problem.
4,76,000, my lord.
Yeah.
Total income.
4 lakh, that is the income, not turnover. Turnover is different.
But two, my lord, if need be, my lord, let it be taken at 2, my lord. I'll place the income tax. My lord, what is required to be, my lord, placed. Your lordship will, the requirement has to be there. The requirement is.
I am not going so deep into the matter. Today's just come up for the first time. The only issue is whether the NIT has been followed or not. That's all.
And second, my lord, they say that professional tax. Professional tax payment has been already annexed there.
I'm not on professional tax. Who has said professional tax?
They have also done.
What? You have said something about professional tax. What?
But He was in area of the dues for professional tax. He has paid up to the month of March 2023. 23.
Ah.
Tender was submitted in December 2023.
Ah.
And the professional tax fall due in the month of September. So from April 2003 to September 2023, he had a time to pay. He did not pay till.
That is for does it say what does it say regarding professional tax? Let us see. What does it say that,
The professional tax clearance
page
certificate.
30?
Page 33, professional tax clearance certificate.
Oh,
That's it.
so it
he has-
doesn't, it
he has-
doesn't give you from a particular date.
He has,
So that is, some leeway has to be given to the authorities to this. You cannot, you cannot impose your standards upon the government. They can have their own standards.
because they have relied on Rule 296 of the Assam Excise Rule, which diverges from giving the Lordship may kindly, this has been quoted also by them, my lord, at page 27, Rule 296. See, to any person who is in arrear in respect of any government revenue or dues, or is defaulter in respect of payment of any government loan, license of retail sale of any shall not be granted. Rule 296, page 27, license of retail sale of any intoxicants shall not be granted. C, to any person who is in
Well,
arrear in respect of any government revenue or dues. So, my lord, from March to September, my lord, he did not pay. He paid the.
But then, that is for the government to ask whether he's in arrears or not for you.
Dues, my lord, lordship.
Correct, but then it's for the government.
Because rule, my lord, professional tax.
No,
my
but
lord,
you cannot take the role of the government. You are not, you are just a tenderer. If they find that he's in arrears or he might be in arrears, they can ask.
lordship, that they did
That
not
is,
do.
yes, you cannot take the role of a policeman. Anyway, yes. Yes. Yes, call 1 minute. Yes.
My lord, I have just my lord, come across my lord, one of the similar process of bidding in the Sonitpur district. They have rejected while my lord, the income tax certificate, income tax return and the balance sheet are not certified by the CA. And perhaps the same was my lord, his item at 45. His standard was rejected because IT was not certified.
Huh?
If my senior cook is addressing some issue.
No, I'm not.
I'm like,
No, no. What, I'm not
What do you
in
mean?
that case. What I'm saying, the government is following, the authorities are following that if it is not certified, this IT or the balance sheet not certified, then it's to be rejected. That's what my lord, the instance my lord, I have given.
Yes,
with
sir.
regard- With regard to Sonitpur district. Yeah, lord,
With regard to Sonitpur,
Sonitpur. But the last page, lordship may come to my lord, serial number
5.
5, my lord. 4 and 5, my lord.
Balance sheet not certified.
Not
by CA.
certified. 4 is IT not certified. And in item 11, his tender was rejected because item 45 tender was rejected because IT was not certified by the CA. My friend has. That's all.
So I think with some examination is required.
With respect to the matter, just pinpoint to
Huh?
my lord will examine the matter, my lord.
Yes.
My lord, here the my lord person who submitted is Pallab Jyoti Construction. Pallab Jyoti Construction submitted the bid. Now the petitioner is Pallab Jyoti Goswami.
Acha.
He claims to be the proprietor.
Palab
Pallab
Jyoti.
Construction. My lord, if they have not annexed the, my lord, in another petition, my lord, I have found. Pallab Jyoti Construction, they submitted the bid. Yes.
Palab Jyoti construction submitted.
Submitted bid.
What is Palab Jyoti construction?
I have given explain in paragraph 1. Yes, they have stated that yes, Pallab Jyoti Goswami is the my lord, proprietor of Pallab Jyoti. Concern.
Then, same thing. Doesn't matter. I just, 2 minutes. This change in weather, not getting cured. All right. Heard Mr. P.J. Saikia, the learned senior counsel for the petitioner. Assisted by Mr. A.K. Gupta. The petitioner's case is that he took part in the tender process for grant of IMFL retail off license for shop number TSK 10 at Jelapokri, Tinsukia. The technical bid of the petitioner, the respondent number 5 and one Shri Manoj Agarwal was accepted. Pusta. The respondent number 5 who had quoted how much?
He quoted for the 31 lakh. I 31 lakh.
31,
30,
comma,
30,
30, comma,
111.
111. Was selected. No, was was L1. No, H1 was H1. As compared to the petitioner who had quoted an amount of
26 lakh.
26, comma
46 lakh. 50.
26,000, huh? And was H2. H2. Next para. The petitioner is aggrieved by the fact that letter of acceptance dated 26 to 2024 has been issued to the respondent number 5. Even though the bid of the respondent number 5 was found to be deficient.
Technical bid.
Technical bid of the naturally. Technical bid of the petitioner was found to be deficient in terms of the tender notice. Next para. The petitioner's counsel submits that in terms of clause 6 of the tender notice, comma, a tenderer has to submit copy of income tax returns along with balance sheets for the year. It is here, huh? I made it in red, page 32. That entire paragraph, huh? 3 lines. He submits that though the income tax returns, he submits that though the net worth statement of the respondent number 5 was certified by a chartered accountant, comma, the copy of the income tax returns along with the balance sheets had not been certified by a chartered accountant. He accordingly submits that the license cannot be issued for the IMFL of retail shop to the respondent number 5. In view of the fact that the technical bid of another person in another tender notice pertaining to the grant of IMFL of retail license had been disqualified as the balance sheet and income tax return had not been certified by a chartered accountant. Full stop. Issue notice. Returnable in 2 weeks. Mr. KP Pathak accepts notice on behalf of the respondents number 1 and 2. While Mr. S.R. Barwa accepts notice on respondent number 3 and 4. Mr. M. Das accepts notice on behalf of respondent number 5. The respondents all being represented shall file their affidavit within 2 weeks. To sublist the matter after 2 weeks. In the interim, the state respondents are directed not to issue any license to the respondent number 5 pursuant to the NIB dated 29/11/2023 till the next returnable date.
Only one thing, my lord, other case, my lord is referring, where the rejection was on the ground of that was in the solid food district, my lord will make.
Okay, whatever I said, somewhere you add, somewhere, you just say, the rejection of the technical bid in the technical of the rejection of the technical bid, which has been relied upon by the petitioner's counsel, relates to the Sonitpur district.
My lord, in this case, my senior pen has referred regarding Sonitpur. Only on 2 grounds, my technical bid has been rejected. In the hard copy, in the envelope, I did not mention as hard copy. First ground. Second ground, I did not submit income tax return duly certified by the CA. My lord,
Yeah, sure. Then,
my lord, their instruction is in the government.
in your favor?
Yes. Just now, yes.
No, that
It's a
Sonitpur is not in your
My
favor.
lord, computer generated. It is computer generated.
Mr. Counsel,
Yes.
Mr. Counsel,
Yes.
please look this side, please look this side. I'm talking to you, please look
Yes.
this side. Okay. In that Sonitpur, what happened, the technical bid was disqualified on the ground that the income tax certificate, in return, and the balance sheet.
Balance is not there.
No, anyway, one is enough. We don't need 20 reasons. In the income tax return, that was not certified by the chartered accountant.
My lord, page 76. Just have a look in my case.
Ah,
In my case, page 76, comparative statement.
Mr. Counsel, first of all, you have got to get over that aspect. In one case, the excise department has, in Sonitpur district, the excise department has disqualified the technical bid
Yes, on that.
on the ground that it is not certified, that income tax return is not certified by a CA.
This is that case.
This is that case. Oh, this is that case. Okay.
This is a minor ground, my lord. Two irregularities, hard copy. I did not mention as hard copy in the envelope. That is the reason. A second ground is that I have submitted all the document. It is not the case that I did not submit. I have submitted balance sheet, turnover certificate, net worth certificate.
Yes, what do you say?
There is one more major ground, your lordship, which I like to point out. The requirement under the tender is that the excise rules have to be followed in toto. Even an undertaking is taken from the applicants, regard that the excise rules have to be followed. Now, as per the excise rules, Rule 63 demands that every application has to be accompanied by a court fee amount of rupees 24.75. It's a very small amount otherwise, but it's a mandatory requirement because the word is shall. Now, that is one of the grounds on which, because the other bidders have submitted, he has not.
The ground of rejection is not that.
On page
Yes.
73, it is there.
My page 76 in respect of me.
Just a minute, one at a time. Page 76.
Yes, my lord. bottom portion, my lord.
We'll have to see what are the reasons given
Yes,
okay, by the tendering authority. Yes,
Document and Assam Excise Road.
yes,
Overall remarks, the applicant, Dinesh Mili, myself, has not adhered to the following points as per the document of
wait, where are you reading?
last portion, my lord.
Last
Page
portion, yes,
76.
yes. Not adhere to the instruction as a
In the bracket
point.
portion, my lord.
Ah,
The envelope is not made
Marked.
marked as hard copy of technical. This is the minor reason, my lord. And second is IT return not certified by CA. My lord, RT accept that I have submitted all the certified copy. And it is a computer generated copy. Everybody can scan, everybody can check. That's not my heinous. Refer to you.
no, now he's like a chameleon.
Yes, my lord.
He's a turncoat.
Yes.
Now he's going to change
My
his
lord,
color.
page 40. This is
Page
page
73 once, your lordship.
My lord, page
Same
40.
document, the beginning of that document.
My lord, page 40.
Just a minute, let me hear you first.
Very good.
Page
Page?
40, my lord. Page 40.
Page 14,
40, 40.
40.
Clause 19.2. The tender.
Just a minute,
Yes.
let me turn to that page. Yes.
That-
Tender.
The tender or
Yes.
bid committee overseeing the bid reserve the right to waive minor irregularities. To my understanding, my lord, these are two minor irregularities. My lord, they can evoke that clause also, my lord. In the
That is to be done by whom?
my lord, authorities, my lord, in
Ah.
spite of
So
Wait.
they have the right to waive.
yes, my lord. This is
So
minor irregular-
and does it mean that they have to waive?
they have the discretion, my lord.
Then
They have the discretion. As my humble submission would be that only two grounds, hard copy that was not mentioned, IT return, it was not certified, but except that they have not shown any other reason
Okay.
while rejecting my tender bid, my lord. And page 78, just a bit look, my lord.
it's 78. Yes.
This is a predetermined, to my understanding, this is a predetermined document in favor of the private respondent.
Why?
Because the comparative statement was prepared on 16 to 2024.
Huh?
And the technical bid was admitted on 7 to 2024. But prior to that,
No. What? Page 78.
yes, my lord,
Yes.
that there is joint inspection report in favor of the private respondent. My lord, when the technical bid was not open, before that, they have verified and came to a conclusion that the site of the private respondent may be considered. And accordingly, but on minor ground, on minor technicality, my bid has been rejected, my lord, very minor ground. And in respect of my lord, private respondent also, there are some minor reason I have seen, minor irregularities that has been ignored. My lord, your lordship may be pleased to see page 89.
Yes.
Networking certificate, there are two dates are mentioned. As on second line, this is to certificate so and so, as on 31/3/2022. And next my right portion, as on 31/3/2022, 23. So this is also minor reason, minor technical error. That may be typographical error, but there has been waived. In my case, only ground of two reasons, my technical bid has been rejected.
What is your bid amount?
Well, to my understanding, it is not open much, 51.
What has not opened?
51 lakhs. I
This
don't,
has not been opened because technically
I am taking
technically disqualified.
Okay.
Otherwise, it has been finalized.
How much?
51 lakhs 995. To my understanding, his bid value is very low, my lord, than me, but it is not open, so I cannot disclose.
How much is your bid?
Well, after the instruction, I was told 1455, something like that.
14, 14.
1455, something like that. But if I may address your lordship somewhere after he is done with it. We have not yet reached the financial bill evaluation for him. He's out of that, on the technical. The question is whether your lordship will be fair on the ground. He says, and he admits to that. He says, and he admits to the question that yes, I missed. Yes, I had some error. There were some defects in my bids, and that's an acceptance by him. He seeks to invoke 19.2 of the clause that the tender bid committee overseeing the bid reserves the right to waive the minor irregularities. Essentially, the law by the Apex Court on this point, that when your lordship is construing a tender clause, Very good. Lordship may, the jurisdiction is there. When it needs an interpretation of a tender clause, who are the authority present, would my lord exercise that jurisdiction or not? I feel that bench of the apex court in Bharat Court, if I may read the
I know.
That's all, 50. Lastly, we deem it necessary to deal with another fundamental problem. It's obvious that the respondent number 1 seeks to enforce the terms of the NID. Inherent in such exercise is the interpretation of contractual terms. However, it must be noted that judicial interpretation of contracts in the sphere of commerce stands on a distinct footing than while interpreting statutes. The High Court ought to have deferred to this understanding unless it was patently perverse or malafide. I put it. There is a treatment judgment on this point, that when your lordship's exercise of jurisdiction requires an interpretation of a contractual term.
I think we'll have to do this case and the earlier case together.
Yes.
Very well.
So that the excise department
They will
will have to wriggle out from either one of the holes that they've dug. You cannot have both, cannot have your cake and eat it too.
But so far as I am concerned, the LOA has been issued and he has accepted his defects on which they chose not to waive. Let me put it that way. He accepts his defects. I don't have the defects. They chose not to waive. Whether he has a right to enforce 19.2 so as to have a direction in the nature of mandamus from your lordships, directing them to waive. That
No,
will too far, madam.
they can consider that
My
there's
lordship,
no
when
way.
I've already been issued the LOA, my financial bid being opened. This is a position where third party rights, Vegraj Singh, third party rights.
But then when you see, with regard to the chartered accountancy, when they're going in two opposite directions, which direction should we say is the correct direction taken by them? They will have to say that.
My lordships, in the
So
other
they'll
case,
have to clarify that aspect.
other case, I am not there, so I would not hold a brief.
That
on
is why.
But so far as this case, it's also that he has not submitted a hard copy and something else.
I have submitted the hard copy.
Yes, I mean, he has not said that it is hard copy.
Only hard copy.
Very
It's
well.
a minor
He-
dispute, my lord.
My lord,
We will see.
he has a right.
I've
to say that he
heard.
committed a mistake.
I've heard. I understand your point.
And my lord, page 78, there is another.
Anyway, enough. Not another point. One another point. You cannot challenge everything under the sun.
That is, my lord.
You have to first, you yourself has to first come out from that disqualification stage. Then you can make a challenge to others. Prior to that, you cannot.
On the same ground, another person has been granted in other matter.
Yes.
On the same ground,
I don't know. Let Mr. KP Pathak explain to us. That.
Stage my lord, notice may be done. And the LOC may be stayed, my lord.
Page number 73 for once.
It's 73 years.
This is the same document which my learned friend was referring to. There, the shortcomings in his bid are reflected. Hard copy of the technical bid submitted, yes. Lordship may have serial number 7, Court fee stamp of rupees 24.75 attached to the application as per Rule 63 of the Assam Excise Rules 2016 and para so and so of the Annexure B of the bid document. No, he has not done it.
But Mr. Counsel,
Ground of rejection.
that is not a ground for disqualification.
But-
Now it basically means, it implies that you have waived. You have waived this.
But that is a mandatory requirement. It is not,
You have got a right to deviate.
yes, of course.
Yeah, so you see, when you have not used this as a ground for disqualifying him, you cannot now bring it up out of thin air.
It is
There, no doubt, but then you have not said anything about it.
It is otherwise reflected in the same document, so I thought I'd point it out, because this is the same, this is the minutes of the technical.
You have read the judgments so many times.
And one more aspect, my learned friend was saying that about the inquiry report, that is what has happened. The date of opening of the technical bids was in December. So after the bids were opened, prior to evaluation, we have to call for a report so that everybody cites it.
In the month of.
Anyway, right. No point
But
wasting
so far
time.
as page 9 is concerned, he's taken a stand. That stand is relevant.
What page?
Page 9 of the writ petition.
Yes,
The writ petition has taken a stand. So far as the second ground is concerned,
second ground meaning?
rejection of 2 counts.
I think.
Others are waived. He cannot argue that. Others are waived. I admit to that. Others are waived. Paragraph 8, page 8, last part. That with regard to the second ground of disqualification, that IT return not certified by CA,
The petitioner states that as per para 6.2.5 of the
Wait, which para?
page 8, paragraph 8,
Yes.
that with regard to the second round of disqualification, that IT return
Direct
not
quotation.
certified by CA. The petitioner states that as per para 6.2.5 of the tender document, copy of income tax returns along with balance sheet for the year 2019, 20, 2021, 21, 22, and 22, 23, bracket any 3 years in sequence close, and statement of net worth as certified by chartered accountant are to be submitted. Accordingly, the petitioner submitted all these aforesaid documents as required. However, the petitioner submitted computer-generated income tax return so and so, so and so, so and so, and therefore it is not required CA certification. The identical case in the history of this background, the laws on this, Milord, that if it is required to be submitted in a particular way, you need to do it. If in doing it, there's an error, waiver. If you've not done it, you chose your own way out. You cannot invoke 19.2. That's my case. No cause for a stay. Milord.
Okay, let us see the clause
Absolutely.
regarding this chartered accountant.
6.2.
Same.
Same clause. Then
Yes,
you see there is
Page
that
31.
word and
Yeah.
comes
And-
later.
page
Ah.
31.
May I read, Milord?
Huh?
Copy of income tax returns along with balance sheet for the years 1920, 2021, 21, 22, and 21, 22, 23. Any of the 3 years in sequence and conjunction comes.
And
Statement of net worth as certified by a chartered accountant. Whichever way they read it, it has to be submitted.
it has to be submitted. But then can it be that only the net worth requires certification by the CA?
Whatever it is, his stand in my case is paragraph
His stand, forget his stand.
is online.
You forget his stand. We have got to see the meaning and purport of the clause therein
My lord.
and what they make of it.
I can argue both ways on that, but
No,
I understand.
you can argue both ways, no doubt. So that is
but
why
they
we
said-
are asking you to sit down. He has to take a decision whether he has to go this way or this way.
But so far as his stand is concerned, he
So
says computer
okay.
generated.
So what is, since you can argue both ways,
No, he
please
says,
argue the other way. How will it be?
well, to be fair, he's taking a stand at page 9. His stand is this.
We're wasting time. No
No,
point. It's just now
That's not
academic interest right now.
Yes.
We will take a final call on this.
The value is
After,
higher, my
huh?
lord, than- my the value is
No, we-
higher than.
Does not come.
We do not know.
Open, my lord.
That issue doesn't arise yet. Heard, Mr.
Answer.
N. Sharma, learned counsel for the petitioner, who submits that the petitioner participated in the notice inviting EBIT bracket NIB dated 14/11/2023, inviting electronic bids for grant of India-made foreign liquor bracket IMFL retail off license at 18th mile under Siloni GP bracket rural, Sonitpur district. Full stop. The next para, the petitioner's technical bid was rejected on two grounds, huh? At page 76, I'm putting it in red, huh? 1 and 2, 1 and 2. Okay. Full stop. The petitioner's counsel submits that the marking of the envelope required, no, the petitioner's counsel submits that the non-marking of the envelope as hard copy of technical bid, huh?
Yes.
A hard copy of technical bid is only a what?
Unless I have to submit it two document, online document and hard.
What is it? It's a minor.
Yes, minor
10.5.6, page 38.
It's a minor irregularity.
Yes. Then
Irregularity. Full stop. He further submits that the IT return submitted by the petitioner which had been computer generated does not require certification by a chartered accountant. So, he accordingly submits that the no, he further submits that in terms of clause 19.2
That's 40.
of the NIB, comma, the tender slash bid committee overseeing the bid has the right to waive minor irregularities. Full stop. Accordingly, the minor irregularity of not writing the words hard copy of the technical bid. What do I say? Accordingly, should be waived by the uh, tender slash bid committee. Full stop.
Second ground wise.
He also submits that in the case of
The page 70 also that.
no. Huh?
WPC 1496 of
Huh?
WPC 1496 of
I also submit that in the case of in WPC 1496 of 2024, the state respondents had had accepted the tender documents of a person who had submitted income tax returns which had not been certified by a chartered accountant. Next. Issue notice returnable in 2 weeks. Mr. K.P. Pathak accepts notice on behalf of 1, 2, and 4. 1, 2, 4, 5. Ms. Udas for 3, 3, 6, 7. And Mr. S. Banik for
R8 and on KVIT also. The KVIT is.
R8. Full stop. As R8 slash KVIT. As the KVIT has been represented, the KVIT stands discharged. Full stop. Huh? Then you write Mr. S. Banik submits that the the waiver of any minor irregularity is the prerogative of the tender slash bid committee, and the decision to waive any minor irregularity, comma, if any, should be decided by the tender slash bid committee. Huh? Full stop. In this respect, he has relied upon the judgment of the Supreme Court in the case of Bharat Coking Coal in Limited and others versus 2020 16 SCC 759 para 15
Para 50
50
at 776.
para 50 wherein para 50
50 at page 776.
lastly we deem it this wherein it has been held at para 50 as follows, huh? Full stop. Next. Uh, the respondent shall file their affidavits within 2 weeks. In the interim, no license should be awarded to the respondent number 5. Eight. It persons to the NIB dated 14/11/2023
So both the matters be listed together.
till the next returnable date. List the matter along with WPC 1496/2024
Obliged.
after 2 weeks.
Highly applied, sir. They did the letter.
This is required.
What's
How
the
did
status?
Huh?
Difficult. Because the license will not
Huh?
eventually someone has to get the license.
No, one of you will get. Someone will get.
Yeah,
But
and
let there be clarity on this issue. They cannot, you know.
Also, in that case, it has happened in case of all the districts because the tender document requirements are the same for all the districts.
Only?
For all the districts, the bid document is the same.
Correct.
So the requirement of the bid document is same for all the districts
Correct.
all over Assam.
Yeah.
So if they waived it for us, they may waive it for others also. Because there is no rejection other than Sony.
Issue has arisen, your lordship, because the bid documents are safe, but the final decision-making authority has been left with the concerned district collectors across every district. So each of them.
the
So
all
we-
IMFL license pan Assam will be stalled.
We have to clarify this issue. This has to issue, otherwise it's unfair.
But can you see on the first of April?
I don't know. What is first?
No, Monday no, sir.
Fourth is Thursday.
We have already fixed some matters. I do not know. What you can do is you can at least file your affidavits by then. File the affidavit within 2 weeks because the issue is very small. Issue is very small.
It's a question of interpretation, my lord, whether that and will be, my lord, read.
So that have to be interpreted by them.
Lord,
They have to kick out one of them.
Ultimately, my.
Either he will go or he will go.
Ultimately,
He will go, the other one will go. I don't know.
ultimately, my lord will interpret it, my lord. Final decision will be given.
No,
by-
no. According to them, they are the authority. We are nothing. So either you will go or he will go. I mean, not you, sorry. Either Mr. PJ Sankhe will go or he will go.
Yes.
Give a date, any date. I mean. Okay, fourth.
Fourth. Alright.
14 to 17.
This week.
Let me go again to the appellate authority order.
Yes, my lord, that is, your also will find it page 102, annexure 10. Maybe.
Okay, this one seems quite, yes, this is good.
Lord, the appellate authority recorded a finding that the matter comes within the purview of clause 5.8.44. But since that application of that clause bore negative result for APDCL, so they applied some other provision. In fact, the matter is covered by a judgment of the Supreme Court.
No, anyway, but leaving that aside, I didn't know that this one was, I thought it was like the other one because I saw one judgment, one order of the appellate authority. It is same as yesterday, short.
No. Yes. The issues in all four cases, the stand of the APDCL is there, the matter is tempered and there is a theft of electricity. So the
specific provision is provided for calculation of the
Tampering.
assessment bill.
Just give me that item, just give me that item 14. Just want to see something.
14 and 15 have those similar orders, very small orders with not much details.
Your
Where is that item 14 order?
Item 14 order, that says
page 99.
it starts at 99.
Tampered meeting.
Your foreign circuit was found.
Huh?
Foreign circuit was found. So
No,
according,
no, not here, not here. It does, not in here. Out here, there is no foreign circuit.
yes, my lord, page 99.
Acha, page 99, okay. Yes,
On, I am reading from line number 7 or 8, my lord.
Yeah.
On 15/9/14, the meter was open in.
extra foreign circuit.
Yes. So according to the APDCL, this is a case of theft of electricity and tampering. So there is a specific provision that is clause 5.8.44, read with clause 3D of annexure A, where as per that provision, the assessment has to be made. In spite of that, it is the extent of the APDCL that they applied clause 4 to 4.2.2.4. That is applicable for defective meter, not for tampering and theft of electricity. So
So is it a case that you agree that there was tampering?
yes, my lord, they, according to them, this is a tampering.
So you agree?
I agree, my lord.
Okay.
So let the assessment will be prepared as per that, because this will result in negative, my lord. There is negative tampering, my lord. That means, my lord, they have done something to the meter and
what
my
do you-
meter recorded higher.
I don't understand what is negative tampering.
Negative, your lord.
There's positive tampering and negative tampering.
My lord,
The assessment,
my lord, if something, let me complete. If something is done by the department to make the meter faster, my lord, then it will record higher consumption than what I actually consume.
Correct.
That is what has happened here in all these 4 cases. And this honorable court has held that the assessment is to be made as per clause 5.8.44, as well as.
No, one thing, why should why should we accept this order?
Which one?
This 99, page 99.
Yes, this is liable to be set aside. my lord. That has been done below by this honorable court in similar matter, exactly similar matter. They agree, my lord. This is exactly similar.
yes, the Anjali is covered, but there was a review also that was filed against that order, my lord. That review order also is important.
Yes, my lord, that is here. I am giving. The court has quoted the provisions of clause 5.8.44 as well as 6.2.11 below. It pages paragraphs 5, 6 below. 3, 4, 5, 6 below. And at paragraph 8, your lordship will find that the authorities adopted the formula which is prescribed under clause 3D below of the supply code. below. But it was the contention of the respondent that
Just a minute. So this item 14, all the items are covered by this case.
Yes, the issue is similar, my lord.
same.
14 and 15, my lords, how my lords are
And
my lords
in
have
the-
pointed out, the order of the appellate authority is, for lack of a better expression, perhaps a little cryptic. It doesn't go into display. There has to be far better worded. On that ground,
No, there are no reasons at all
there's,
for coming to a conclusion.
my lords was pleased to remand the matter back on yesterday.
No point, my lord.
That can be also.
After 5, 6 years, 7 years, my lord, the petitioner is here, his money is blocked, my lord. Petitioner money, is-
That can be done also here, I know.
and since there is a judgment, my lord.
No, but then if this matter is covered, why should we? What?
But the authority could also, direction to comply with the, whatever the mandate of this judgment, madam. That can also be done. Remanded back with a direction so that the judgment. rendered
Lord,
by
in
an
fact, the penultimate order is that I will file an application for refund and they will pass an order. That is the order, my lord. And in the review order, your lordship will find that the court.
Just a minute, yes, take it easy, yes.
It's what I said, subject to what lordship holds, my lord. If the matter is remanded back with a direction to the appellate authority to decide the issue based on the judgment rendered by the honorable court in SM Siemens matter. That can also be done. ma'am. The review thereafter also goes on to clarify what has to be done. The order.
This. The second order is there, my lord.
Yes.
The review petition
Review order
14 of 2020.
Yes, ma'am. 30th November 2020. Page 3, my lord, stands modified to the extent that the requirement of doing the recalculation be done by following the procedure under clause 5.A.4.4 of the supply code as amended. So that has to be.
In all the cases, foreign material was
Yes, my lord.
detected.
Yes.
Because this, I just look at judgment again, you cannot pass such kind of order. They is quasi judicial authority.
They're technical people, otherwise, perhaps.
But then Supreme Court has said in that Kranti Associates Private
Para
Limited.
47.
Huh?
Para 47.
Para 47.
47.
Yes.
May I please?
That, yes, perhaps I'll bow down to that fact.
Ah.
They're technical people who actually do not know how, perhaps that order has to be better worded. There has to be reason.
Because you see, there is nothing there. They just talk about everything and then they say foreign material. And that's the end of the matter.
What subject to what lordship holds, it can be remanded back. They have to give a fresh certification of all the
And
aspects.
my lord, I have given one more judgment, my lord. There, this honorable court has held that for tampering the formula is prescribed under clause 3D. That has to be added. Para 18 of the other judgment.
So we can remand this back to the first appellate authority and let them take a decision on the basis
It
of
will
this.
be before the area manager.
Ah.
The area manager issued the assessment bill. So the matter will go to assessing officer with a direction to recalculate the assessment as per provision contained under clause.
No, we're sending it back to the first appellate
There is
authority.
a clear direction from this on the court
Okay.
that the assessment has to be made as per clause 5.44 and read with clause 3D.
No, because we have got to teach a lesson to these fellows to pass some proper orders.
They will again write something, my lord, then again petitioner has to approach. There is not a single case, my lord. At least I appeared in thousands of cases, my lord. I have not find any single judgment which is decided against the petitioner.
But then that item 17 was nice.
17 and 18.
Item 17 is worded properly.
Properly, but then your lord will find. He admits that the case is covered
You
by.
see, whether they are wrong or right, that is not the issue. The issue is at least they have made some proper.
effort is-
Yes,
Yes.
some proper reasoning.
Yes.
And some proper finding has been made. In the cases of this, the first two cases, there's nothing here. It's only on that ground. So what we can do is 14 and 15 we can send it back. 16, 17 we can do that.
Your lordship may same matter.
Actually, then
The
since it's already decided,
Yes.
we dispose it of in light of this.
Yes,
I'll leave it to my lord.
What else? Because for him also to go back and again do the same exercise is difficult.
The review order will be also important. The
Yes, the
recalculation.
review order is, as well as, my lord, the other judgment given para 18, only 18.
Huh?
Judgment rendered in 2057 of 17, my lord.
Two-
Paragraph 8.
Just a minute, 2057?
Yes, my lord, I have.
Huh?
2057 WBC.
Where 2057 is? 2057 what?
This is another copy B,
Okay, okay.
paragraph 18. For tempering, the formula is given below.
Yes, have you seen this?
They appeared me.
My friend had appeared, my lord. There's a formula prescribed
Yes,
in the AERC regulations itself, my lord.
Yes.
A copy of that I have passed, my lord. Because what essentially the judgment that my friend here is relying upon, it says there is a table appended to the provision, my lord. My lord, may kindly take up, kindly have page 120, 1221, my lord. of the
Yes, sir.
code. AERC regulation.
These are all different entities, correct?
yes.
There's so many documents.
Yeah.
Which one do you want?
There's notification, my lord, the electricity supply.
885.
Yes.
Eight.
2007.
Ah, yes.
So, my lords, page 1222
1222.
is the same exact provision that the judgment speaks about, my lord. When a consumer indulges in theft of electricity, the officer authorized 5.A.4.4, my lord, bottom of page 1222.
Yes.
When a consumer indulges in the theft of electricity, the officer authorized in this behalf by the government of Assam may, without prejudice to its other right, will assess the quantum of electricity loss on the basis of assessed consumption of defective category as per table under 6.2.11. The table, my lords, is at page 1225, my lords. Yeah.
One double two five.
1225 of that very same regulation notification.
I've got this one, no, 1225.
1225. 2 pages thereafter, my lords, from 5.8.
Oh, this is 5.A.4.4.
Page number 1225.
And this is
122. Yes, yes.
There's a table at my lord 6.2.11.
Yes, yes.
Item number 9 of that table, my lord, serial number 9
Yes.
is relevant here. So the calculation or the recalculation for that matter has to be done as per the table, my lord. But para 18 perhaps would not be relevant.
your lord's kindly see, this is the tempering formula is prescribed. And that has been reflected.
The judgment says, my lord,
So that is
5.8.44.
the judgment,
based on
second
the-
judgment that has been done with. This is for tempering and that case is tempering.
No, no, I don't know. Let me see the judgment. The appeal filed by the petitioner before the appellate authority constituted under one stands restored to file.
Which
In this, acha, this is a different order.
that is different, my lord. In that case, the appeal assessment was made as per clause 5A44.
5892 of 2017. SM Cement. Para 3, my lord, of that judgment
Yes.
is a reproduction of that 5.8.4.4. Thereafter, my lord, para 4 of that judgment again speaks about the computation of load security. And at page 4 of that judgment, my lord, there is a reproduction of that table. Item serial number 9 of that table is relevant here as well.
Para 4.
Para 4, my lord, PN4.
Ah, it's given here.
Yes, my lord. It's a reproduction of the provision, my lord.
para 8 your lords may kindly also see this.
Yes. Now, para 8 and 9, my lord.
By taking note of the figure, the authorities adopted the formula of deducting. It is required as per clause 3D. Because the consumption already recorded by the meter, they are required to apply the estimated consumption by 2 times. That will be the estimated consumption. From the estimated consumption, the consumption already recorded by the meter that has to be detected, and the balance will be treated as loss. And on that basis, 12 times, 12 for 12 months, they will make the assessment at 2 times of the applicable rate of pay. It is the formula. But if my learned friend is in doubt, my lord, I will place their appellate authority judgment. In that case,
Yeah, give it to him.
yes, that formula is given me. Your lordship may kindly. There also the assessment assessing authority has done some mistake. The appellate authority has corrected it. Third page, your lordship may kindly. हम लोग एक
Whereas, I'll leave it to my lordship that order that my friend here is referring to, that assessment would otherwise be done by the SD, my lord, or the officer concerned. As per the calculation, as per the judgment rendered by the another coordinate, that can be done. That formula, that calculation, my lord, that they will go in.
Let them decide.
Yes.
They will again calculate. This was the mistake, my lord. In that case, your lordship has seen estimated consumption was multiplied by 2 times instead of before deducting the recorded meter consumption. That is why the petitioner has approached the appellate authority. Appellate authority has corrected. They will again commit the same mistake. my lord.
Then let it go to the appellate authority. Let the appellate authority pass the order. They'll know better.
That authority, my lord, they are not following their own order, my lord.
They'll follow.
They are not following, my lord. Your lordship may only make.
I'm not sure, no. I'm not sure.
Let it come up on some other day. I will make my submission. Because whatever submission I am making, my lord, I am making as per the provision of law.
Problem is, I'm not a technical person.
Lord, this is actually the formula prescribed, the statutory provision, my lord. Your lordship is aware. These are the statutory provision for assessment of,
Show me how.
my lord.
Show me. How this 5.4 has to be, 5A.4.4 has to be applied? Do you agree with him? No.
Yes, my lord, they
As
cannot.
far as the application of 5.4 is
If-
concerned, that has to be applied.
Yes,
Can
that has to be done.
Yes, now, whether, as Manoj may demand it back to the authority to decide that issue based on that calculation under the table appended with 5.4.8 or to the assessment officer. That I leave to Manoj.
In that case, my
As
lord,
far as
they
the
will not
formula
deduct the-
goes, Manoj,
they will not deduct the consumption recorded by the meter, my lord. It is the problem, my lord. That is why I am placing the other judgments. They are supposed to deduct the consumption already recorded by the meter.
But why didn't this court also clarify that issue then?
my friend that was appearing in
You had all the time then.
My lord, that is why I have placed the other judgment. Other
But
two
then the
judgments.
problem is that I'm not that clear about those issues.
In fact, your lordship will find that was my submission before the appellate authority, before the area manager. I have specifically stated that the assessment has to be made as per clause 5.8.4.4, read with serial number 9 of clause 6.2.1.1 and clause 3D of annexure A to the supply. That is my submission, my lord, before the authority. And your lordship, appellate authority is also writing apply clause 5A.4.4, meaning you have to follow clause 3D. That has not been followed. That is why the clarification order is issued in Parvati.
So appellate authority will clarify all these issues. Why should we go into this? Let them, they are technical persons. They know more than us.
They will not do.
Huh?
They will not do, my lord. I have not find any single judgment in my favor. I have done various appeals, filed many appeals, my lord. There is not a single judgment.
Well, unfortunately, I'm not a technical person. I don't know whether we can go into those issues.
Let me try my luck in some other court in that case.
Why should I allow you to do bench hunting?
No, my lord. No, your lordship just now said that, no, I do not want, my lord. That is why I never pray for any adjournment, my lord. Technical, since your lordship has said that this is technical.
Since there was a similar case disposed of yesterday on the same line, why shouldn't we dispose of this also? No reasoning given.
So these matters are covered in, because this is only the calculation part. There is no.
Calculation part is not mentioned in the covered in the other judgment by which this case is covered. In this judgment, 5892 that we are relying upon, which you are saying covers this case, has that aspect been clarified? Then
In these first two cases,
then
that is not.
then how can you say that?
Lord, that averment, your lordship will find it from the read petition, their
No.
own statement.
If this case is covered by 5892, we'll dispose it of as 5892. That aspect, so let them decide.
No, your lordship, their own statement before the appellate authority that they have applied clause 4.2.2.4. And my statement was that this should be as per clause 5A.4.4. That stand your lordship will find from their own affidavit filed before the appellate authority, that is annexed in the read petition.
Okay, list the matter after 3 weeks. On the prayer of the petitioner's counsel. Huh? Wait,
Only.
Yes, what is this matter?
Lordship, this case, your lordship, the petitioner is a management of a tea garden, your lordship. Aggrieved by an order, your lordship. At page 22, your lordship, they have prepared this petition, your lordship. And what has happened, your lordship? There is an order by the commissioner, your lordship, under Employees Compensation Act, your lordship.
You've got to pay some money.
Lordship.
How much?
2,81,115.
So why are you not paying?
Lordship,
So you pay the amount.
Lordship, what has happened, your lordship, in this case, your lordship, or the order has been passed, your lordship, ex parte, your lordship. And on that, your lordship will get at page 19. We have filed a petition under order 9, rule 13 of the civil procedure.
Page.
Page 19, your lordship.
Yes.
This is our petition, your lordship.
Then what has happened to this?
Then yes, your lordship will kindly come to page 22, your lordship.
Ah.
This is the order passed by the, which is under challenge here, 22/5/2018. And in this order, your lordship will get first, second, third, fourth paragraph. And according to rule 32(2) of the Workmen Compensation Rule 1924, the company commissioner at the time of signing of doing his judgment shall pronounce his decision, and thereafter no addition or alteration shall be made to the judgment other than the correction of a clerical or arithmetical mistake arising from any accident, slip or omission. Hence, the petition filed under opposite party, filed by the opposite party number 1 under order 19, order 9, rule 13 of the CPC cannot be considered.
Where are you reading? Which page?
Page 22, euro.
Last page.
Last page of the petition.
22?
Right.
Okay.
First, second, third, fourth paragraph is also.
Yeah.
And according to the rule 32(2) of the Workmen's Compensation Rule 1924, the commissioner at the time of signing and dating his judgment shall pronounce his decision, and thereafter no additional alteration shall be made to the judgment other than the correction of clerical or arithmetical mistake arising from any accident, slip or omission. Hence, the petition filed by the opposite party number 1 under order 19, rule 13, 9, rule 13 of CPC cannot be considered and stands rejected. We have challenges on the ground, this, your lordship, that as per the rule 41 of the Employees Compensation Rule, he has referred, your lordship. The commissioner has referred, your lordship.
You are challenging this order.
Yes. We want a chance to place our facts before the commissioner, and your lordship, thereafter whatever order commissioner passes, your lordship, we will abide by that, your lordship. Since we have not been able to place those facts, and in fact, what has been submitted, what has been.
Let us see this order dated 12/2/2018.
Lord,
It starts at page
page
15.
15, your lordship.
Yes.
That on 16/5/2015 at about 3:30 AM, while Sri Dindal Malik along with some other workers was cleaning in CTC factory of the garden, made with an accident. As a result of the accident, Sri Malik sustained grievous injuries on his person and lost 3 fingers with right hand. He was immediately brought to KK Civil Hospital, Golaghat for medical treatment, and after providing first aid, he was shifted to Jorhat Medical College, Jorhat. He was treated there as indoor patient. The claimant has lost his 3 fingers of the right hand, as a result of which he became permanently disabled to under livelihoods. He sustained injuries during the course of an outdoor employment. The claim petition has been registered and so and so. Notices are also for making appearance and to answer the allegations laid down in the claim petition by filing written statement. The opposite party, after receipt of it, have filed a petition for seeking time to file written statement, but later they never appeared not to any step the case. As such, the case is proceeded ex parte against the opposite party. Then your lordship. Discussion and decision there of your lordship. The opposite party failed to represent the case in spite of receipt of notice. As such, the case was decided ex parte. However, from the statement of the claimant and document of record, it is proved that there was a master and servant relationship between.
What do you want to say? His he's your workman,
Lordship.
then why are you challenging this order?
Lordship, since your lordship, we have not been heard. That's the only issue, your lordship.
And we are hearing you now.
No, your lordship, that probably will, then your lordship, then the question of taking evidence, etc., everything will arise, your lordship.
No,
That
no,
question of-
is it your case that he's not your workman?
Lordship, that stand we will definitely take, your lordship.
No, no, what is your stand? Take before this court.
Since your lordship will kindly come to my petition, your lordship. Your lordship will get the petitioner on receipt of the reminder notice appeared before the learned commissioner, para 4, your lordship. 5, and submitted the letter dated 39/2018 of the respondent number 2 worker, wherein he has stated that the petitioner has paid all his medical expenses and has also paid his full salary while he is on leave. But sufficiently said letter and documents are not available in record, though the same was submitted on 5/1/2018. Those documents we have submitted that he was on leave. Then the petitioner, these are the facts, your lordship, which will have to be, your lordship, placed by way of filing evidence, your lordship, before the learned court below, your lordship. But then before the learned commissioner, your lordship. And then, your lordship. And these facts, your lordship, have bearing on the matter, your lordship. And we have paid them, him.
Yes,
First of all, I want to bring on record that the application which has been rejected, dated 22/5/2018.
yes,
They filed this application under Order 9 Rule 13,
yes.
against which there is a provision for appeal, statutory appeal.
Okay.
There is specific provision in the CPC for statutory appeal.
Yeah,
Under-
what is the appeal?
Under Order 43, Rule 1D. So they have straightforward.
Yes, yes.
Order 43, Rule 1D. Appeals from orders.
Order 43,
Order 43,
XL, no?
appeals
Yeah.
from order 1D.
D for Delhi.
D for Delhi. An order under Rule 13 of Order 9 rejecting an application for an order set aside with degree past expiry, from which an appeal lies. And another thing I want to bring to your notice that.
So we dismiss the appeal.
Dismiss. And another,
Lordship, I will show that, your lordship. Your lordship may kindly take up the rule, your lordship, Workmen Compensation Rules 1924. Which provision of CPC is applicable for so far as employment or employees compensation act is concerned? That is specifically made in the Rule 41, your lordship.
No, no, so, huh?
Rule 41 of the Employees Workmen's Compensation Rule, your lordship. Forty-three, no, 43 কোথায় করেছি? That copy is not. Only one copy I can do.
Okay. We can all share.
Your lordship will find in Rule 41, your lordship, which provision of CPC will be applicable, it was specifically mentioned. Order 19, your lordship, Order 9, your lordship, as a whole, your lordship applicable so far as this is concerned, your lordship. But Order 43 is not there, your lordship. That says that this will be applicable, your lordship. Until and unless this provision is included, your lordship, that particular provision of CPC will not be applicable in our case, your lordship. And in fact, your lordship, the power under your lordship appeal as well as your lordship, this your lordship are two different, your lordship. And that has been decided by the your lordship, apex court in a judgment, your lordship will get it, your lordship. And they should have filed an affidavit, your lordship, to bring all this to record, your lordship, pleadings, so that I could have, your lordship, responded to it, your lordship. Para 10, your lordship. The scope of order 9, rule 13, your lordship, has been discussed in this para 10, your lordship. In why your lordship an appellate provision, your lordship.
Yes.
A conjoint reading of order 9, rule 13, CPC and section. This is in relation to appeal, your lordship, against ex parte decree. 1996 to CPC indicates that defendant who suffered an ex parte decree has two remedies. Either to file an application under order rule 9, rule 13 CPC to set aside an ex parte decree to satisfy the court that summons were not duly served or those served. He was prevented by sufficient cause from appearing in the court when suit was called for hearing. To file a regular appeal from original decree to the first appellate court and challenge the ex parte decree on merits. Then it is to be pointed out that scope of order 9, rule 13 CPC and section 96 to CPC are entirely different. In an application filed under order 9, rule 13 CPC, the court has to see whether summons were duly served or not, whether the defendant was prevented by any sufficient cause from appearing when the suit was called for hearing. If the court is satisfied that the defendant was not duly served or that he was prevented for sufficient cause, the court may set aside the ex parte decree and restore the suit to the original position. In terms of section 96 to CPC, the appeal lies from an original decree past ex parte. In the regular appeal filed under section 96 to CPC, the appellate court has wide jurisdiction to go into merits of the decree. Your lordship, appellate jurisdiction is slightly different, your lordship, than your lordship, the jurisdiction under order 9, rule 13. The inquiry will be, your lordship, very limited, your lordship. And in fact, your lordship, when statute provided that this particular provision of CPC will be applicable, then the commissioner could not have said that I have no power to exercise the power which has been given by the statute, your lordship. This is my case, your lordship. I want an opportunity, your lordship. If that opportunity, after hearing me, taking into account everything, if authority decides, your lordship, the commissioner decides against me, I will abide by that. And your lordship will see even in case of appeal under this act, your lordship, and the rules, your lordship, substantial question of law will have to be there, only then its appeal is maintainable. It's a very, provision is very strict, your lordship. Therefore, your lordship, my only prayer is that, your lordship, that the order passed by the commissioner is, your lordship, not in.
But what has the commissioner said? What has he said?
He said that, your lordship,
He has not said anything.
he said that according to rule 32(2) of workman compensation rule 1924, the commissioner at the time of signing of dating of his judgment shall pronounce his decision, and thereafter no addition and alteration shall be made to the judgment other than the correction of a clerical.
Okay, okay.
Therefore, your lordship, he has not touched.
My second contention is that under section 30, there is a specific provision in the statute itself for appeal, in which there must be a substantial question of law, and thus the appeal shall be filed within 60 days. There is a provision for
Yes,
appeal.
he has availed of order 39. I mean, order 13.
Then even then,
Order 9, rule 13.
even then the
Order 9, rule 13.
appeal, repetition will not lie. Appeal will lie under section 30 of the statute. Section 30
of the
workman employees compensation.
That is there, your lordship.
Employees Compensation Act.
Rule, act, your lordship.
Act.
Where is the
That
act?
is there, your lordship. Just before that, your lordship.
Before your lordship. Then
In this book.
In this book.
section 30 appeal lies, provides for appeal. And in the repetition also, he has not denied that I am not an employee. The accident has also been not denied. I will show.
Yes.
An appeal shall lie to the High Court from the following orders of the Commissioner.
On that, your lordship,
A, B, C, D, E. Then proviso is there.
Just a minute. An appeal shall lie to the High Court for the following orders of namely an order awarding yes, which one will come into play?
An order awarding compensation of a lump sum, whether by way of redemption of half monthly payment or otherwise, or disallowing claim in full or in part of a lump sum. An order awarding interest or penalty under section 4A. These are some conditions, and there is a proviso. Provided that no appeal shall lie.
No, then there is an order providing for distribution of compensation.
Lordship,
There A to E. There is A to E, A, B, C, D, E.
Five only. Five.
So which one? So which one will come? Which one is applicable?
A.
A.
On that,
And double A also, because interest also, is also been paid. And in fact, no appeal shall lie against any order unless substantial question of law is involved in an appeal. And in case of order of so and so, so and so. So third proviso is also there regarding that no appeal shall lie from an employer under clause A unless the memorandum of appeal is accompanied by a certificate by the
Where are
commission.
you reading? Where are you?
Proviso, third proviso.
Provide further.
Further, no appeals by an employer. under-
That's what when you read, please don't add words which are not there. You said shall lie. There's no shall lie anywhere.
Shall is there, Lordship.
No,
Third
lie is not there. No,
Shall
it says provided further that no appeal by an employee
by an employee under
under
clause
clause A. And
clause
then
A
thereafter,
shall
shall lie.
shall lie unless memorandum of appeal is accompanied by a certificate by the commissioner to the effect that appellant has deposited with him and the amount payable under the order appeal against. And third is there 60 days. The period of limitation for an appeal under this act, under this section shall be 60 days. So appeal lies under this provision. And another thing I want to show your lordship, that they were negligent during before the trial court, because notice was issued twice. May I show the page 15. The opposite party, after receipt of notice, has filed a petition seeking time to file written statement, but later on they never appeared nor took any steps in the case. As such, the case proceeded ex parte against the opposite party. And in fact, in their petition under Order 9 Rule 13, they have specifically pleaded. Page 20. It is to be mentioned here in that on 5/1/2018, the opposite party received reminder notice.
Page 20.
Page 20, paragraph 4. It is mentioned here that on 5/1/2018, the opposite party received reminder notice issued on 21/12/2017, in which the opposite party asked to appear on 27/12/2017. Accordingly, the opposite party appeared on 5/1/2018 and submitted the statement of the worker, etc. But surprisingly, enough the said letter and documents are not available in the case record, though the same are submitted in the court on 5/1/2018. So they received, when the application was filed for compensation, they received the notice. They engaged, as per their statement, they engaged one lawyer. He did not turn up. And second reminder notice was also given to them. Then also they have said that they appeared, but the documents are not on record. Assuming for a moment their application is rightly filed before this honorable court, then also by going through their statement, we can see that they have not denied about the accident. I have lost my right hand's 3 fingers. They have not denied the accident. They have categorically stated that accident has occurred. Page 5 of the petition, paragraph 2. The petitioner begs to state that the respondent number 2, Din Dayal Mollik, is the permanent labor employee of Rongajan Tea Estate on 16/5/2015 at about 3:30 AM, when Din Dayal Mollik, along with some other workers, was cleaning the CTC factory of the garden, met with an accident and sustained grievous injuries on his person.
So they have agreed, they have admitted.
They have admitted.
No,
And
Your
in fact,
Lordship,
regarding
So what do you want? Why do you want to you want to be heard?
Because your lordship will kindly see that we have paid his medical expenses, everything. Your lordship, the quantum of your lordship, the compensation has been granted, your lordship, that it has bearing on that, your lordship. Now, your lordship, that could not be, your lordship, decided, your lordship, that we have paid medical expenses, everything, etc., your lordship. That has not been, and your lordship will kindly see in the appeal, your lordship, as my friend has been submitting, your lordship,
what we will say, Your Lordship, in the appeal? The first bar that will come before us, Your Lordship, that we have not cleared this order will remain, Your Lordship. Therefore, there is no question of Your Lordship appealing against anything because, Your Lordship, we have not able to brought on record anything, Your Lordship. Then first question that will be before the appellate court, Your Lordship, will be that what will be the substantial question of law? Without bringing anything on record, how can we, Your Lordship, formulate a substantial question of law, Your Lordship? Therefore, Your Lordship, only to that extent, I am not saying that, that's why, Your Lordship, we have brought everything. We have not hide anything, Your Lordship, before the commissioner also, Your Lordship. We clearly stated what is there, Your Lordship. Our bona fide is there, Your Lordship. We just want, Your Lordship, an opportunity to place our case. That much, Your Lordship.
Now, 6 years have passed.
Another thing I want to show you to your lordship, page 17. Page 17 of the judgment.
Yes.
The commissioner has awarded this 2,81,115 rupees as per a formula given in the statute itself. The age should be a factor, the loss of earning capacity should be a factor, and the salary of the person. The salary of the person has been was given by 8,000 rupees, but the commissioner has
7,200.
Commissioner has considered this 7,200 as unskilled worker, and 60% loss is 4,320. Relevant factor for age was 25. Loss of earning capacity 30. All has been given in the statute itself. I can show that for loss of 3 fingers, the statute itself provide that I am entitled for 30%. 30%, and thereby
So 30% is given to you.
yes, 30%. I am happy with this, and but thereby the commissioner has calculated that the 2,81,100 and this amount I am entitled. Neither they have disputed I am an employee, not they have disputed the accident. I have lost the finger. They have admitted also. Now, what will change their situation?
They want to pay less. That's all.
Bigger amount has been awarded. And
They want to pay less.
he is fighting from
Probably they have paid more in lawyers' fees than what they want to pay you.
from 2015 he is fighting. It's been now
I think you pay
almost 10 years.
nothing here.
And statutory
My
appeal is
limited
also
prayer,
there.
Your Lordship.
Your limited price rejected.
It's
I
not
think.
That I leave it to Your Lordship.
Have to, I
Lordship.
think. There is two
I
poor
don't- I
person.
don't-
He
I
lost
place my
three.
best after that, Your
He's
Lordship.
lost 3 fingers.
Lord.
You have admitted it. You have paid for his hospital. You should pay. Why shouldn't you pay? He's your employee.
Lordship, Lordship. I
mean,
placed my facts.
Tell your clients, pay immediately. Right. Third, Mr. Esbar Thakur, learned counsel for the petitioner. Also heard Mr.
D. Chaudhary for respondent number 2.
D. Chaudhary for respondent number 2. Mr. Oh, so stop. Right. This writ petition has been filed against the order dated 12/2/2018 and 22/5/2018 passed by the Learned Commissioner, Employees Compensation, Golaghat, in EC case number 12 of 2015. The facts of the case in brief is that the respondent number 2 was a permanent employee, a permanent labor / employee of the petitioner number 1. Full stop. On 16/5/2015, while he was cleaning the CTC factory in the garden along with other workers, the respondent number 2 met with an accident and sustained grievous injuries on his person, which required amputation of 3 fingers of his right hand. Of his right hand. Full stop. The next para, the respondent number 2 thereafter preferred a claim petition being EC number 12 of 2015 before the Court of the Commissioner, Employees Compensation Golagat, which was registered as GEC number 12 of 2015. Yes, sir. The respondent, no, the petitioner received notice of the pendency of GEC number 12 of 2015. However, they did not appear. Correct, they did not appear. Mr. Dibankar, they did not.
They appear, your lordship, then your lordship, no steps was taken.
Full stop. What have I said? However, despite appearing before the Court of the Commissioner Employees Compensation, they did not take any further steps in the matter. Full stop. Next para. GEC number 12 of 2015 was disposed of by the Court of the Commissioner Employees Compensation by the Learned Commissioner, not court, by the Learned Commissioner Employees Compensation, while judgment dated 12/2/2018 by awarding a sum of rupees 281,115 to the petitioner along with interest at the rate of 12% per annum from the date of from which date?
Is from the date of accident.
No.
Till judgment. Till realization. Award is at base 18.
From where? From when to when?
Shall have to pay interest onwards the amount till realization.
From the date of order, award.
From date of award.
Till realization.
No. What have I said?
Subtraction award or compensation.
That 2,81,115 to the petitioner. Full stop. No, full stop. Full stop. Interest was also to be awarded. Interest was also awarded at the rate of 12% per annum
From
from
16.
from 30 days after the issuance of the judgment and order. Judgment dated 12/2/2018. Correct. I think that's
From the date.
till realization. No. It says within 30 days from the date of this order, failing which.
Yes.
So it's after 30 days. only.
After
After 30 days. But 30 days was to be paid. So what have I said? You just say, don't say interest was to be paid. You just say the amount of rupees, the amount of rupees 2,81,115 was to be paid within 30 days from the date of issuance of the judgment dated 12/2/2018, failing which the petitioner was to pay interest at the rate of 12% per annum on the awarded amount till realization. Correct? Next paragraph. The petitioner, being aggrieved by the judgment dated 12/2/2018 on the ground that the same had been passed ex parte, he submitted an application under Order 9 Rule 13 CPC to vacate the impugned order dated 12/2/2018. And to allow the petitioner to contest the case by filing a written statement. Next paragraph. The application of the application of the petitioner under Order 9 Rule 13 CPC was registered as, oh, no, same thing, no, was dismissed by the learned commissioner by order dated 22/05/2018. By stating that according to Rule 32(2) of the Workmen Compensation Rule, 1924, no addition or alteration could be made to a judgment passed by the commission, other than correction of a clerical or arithmetical mistake arising from any accidental slip or omission. Full stop. Being aggrieved with the impugned judgment dated 12/2/2018 and the order dated 22/5/2018 passed in GC number 12 of 2015, the petitioner has filed the present petition. Full stop. The petitioner's counsel submits that हम बुला देगा हाँ. The petitioner's counsel submits that as the petitioner had paid all the medical bills of the respondent number 2, and as the respondent number 2 had received his salary, they were surprised to learn of the impugned order directing them to pay rupees 2,81,115 as compensation. He submits that if the petitioner was allowed to make submissions before the learned commissioner with regard to the expenditure already incurred by the petitioner for the hospital expenses, the compensation amount awarded by the learned commissioner would have been reduced, correct?
Not,
Would have been reduced. That's all.
not.
That's your case only. That's your case only, nothing
And
else.
so far as that part is concerned,
Ah.
that the order 9 rule 13
Ah.
is not
Ah.
applicable.
Full stop. The learned counsel for the petitioner submits that in terms of Rule 41 of the Workmen Compensation Rule 1994, the learned commissioner is competent to hear an application under Order 9 Rule 13 CPC and the decision made while order dated 22/05/2018, that the commissioner cannot make any addition or alteration to the impugned ex parte judgment is incorrect. He accordingly submits that the petitioner should be allowed to that he accordingly submits that the impugned judgment and order should be set aside. No, he accordingly submits that the two impugned orders should be set aside, and the petitioner should be allowed to contest the case of the petitioner of the respondent number 2 before the learned commission. Pusta. Next one. On the other hand, Mr. D. Chowdhury, the learned counsel for the respondent number 2, submits that the petitioner has not denied the fact that the respondent number 2 had lost 3 fingers while working in the CTC factory of the petitioner's garden. Further, there is no denial of the fact that the respondent number 2 is an employee of the petition. Notices having been received by the petitioner in connection with GEC number 12 of 2015 and the petitioners having participated and the petitioner having participated, having attended the proceedings in GEC number 12 of 2015, there was no infirmity in rejecting the petitioner's application under Order 9, Rule 13 CPC. He further submits that what?
As per section 30 of the statement,
As per section 30 of the Employees Compensation Act 1923, the appellant, the petitioner could file an appeal against the impugned judgment passed by the learned commission, which the petitioner has declined to do so. He accordingly submits that the present writ petition should be dismissed as a statutory remedy was available to the petition. Anything else? I have heard the learned causes for the parties. As can be seen from the submissions made and the pleadings, the respondent number 2 met with an accident on 16/5/2015 while working in the garden of the petitioner, which led to the loss of 3 of his fingers. The respondent number 2 was an employee of the petitioner company. And I was an employee with a full stop. The impugned judgment dated 12/2/2018 passed by the Learned Commissioner Employees Compensation shows that the compensation awarded to the respondent number 2. Pertains to his loss of earning capacity, which had been calculated in terms of section 2 bracket 1 and bracket 4. Where is that?
Section 4 is independent.
Huh?
Section 4 is independent. Amount for compensation.
Just a minute. As per section. As per section. Don't say 2-1, just say as per section 4, huh? As per section 4 of the Employees Compensation Act 1923. That's all, no? The schedule is required
The schedule is in the section 4 also mentioned.
and the schedule. And the schedule. Those questions. Further, though the income of the respondent number 2 was rupees 8,000 per month, the learned commissioner has taken the income of the respondent number 2 as rupees 7,200 per month. Full stop. This court does not find any infirmity in the calculation made by the learned commissioner in awarding the compensation amount to the respondent number 2. Full stop. The above being said, the question pertains to whether there was any infirmity in rejecting the petitioner's application under Order 9 Rule 13 CPC by the learned commissioner. Full stop. As stated earlier, the petitioner was aware of the pendency of GEC number 12 of 2015 and had also participated in the same. Full stop. Order 9 Rule 13 CPC provides that in a case in which a decree has been passed ex parte against the defendant, he may apply to the court by which the decree was passed for an order to set it aside, if he satisfies the court that the summons were not duly served or that he was prevented by any sufficient cause from appearing when the suit was called on for hearing. In the present case, there is nothing to show. In the present case, the two conditions have not been satisfied. In the present case, neither of the conditions have been satisfied by the petitioner. The above being said, no, besides the above, the appeal provision, that is section 30 of the Censor Act, of the Act, has also not been taken recourse to by the petitioner. In the case of Radhe Sham versus Chabinath and others, 2015 5 SEC 423, The Supreme Court has held that judicial orders of civil courts are not amenable to writ jurisdiction under Article 226. And the challenge to judicial orders would lie only by way of a statutory appeal or revision or under Article 227, but not by way of a writ petition under Article 226. In the present case, the order passed by the Learned Commission could have been challenged by way of Section 30 of the Act. However, instead of taking recourse to the statutory provision available for filing an appeal, the petitioner has filed the present writ petition. Now, considering all the above, this court is of the view that no case for interference with the impugned judgment dated so and order dated so passed by the Learned Commissioner in GEC number so has been made. The writ petition is accordingly dismissed. Any something wrong somewhere? Any correction?
There is an interim order that will have to be vacated.
Interim order passed earlier stands vacated. Poor fellow, now that money, 2 lakhs is become maybe the value has gone really down.
Rate of inflation.
Anyway, what happened? Yes.
Also, I think respondent 2 and 5. So respondent 5 has been newly implemented in this case. Also, I have the instruction as per the petitioner's contention is that his payment of non-payment of bill as regards during various work order with regard to printing of electoral roll. And that work order has been issued by the Deputy Commissioner, the District Election Officer. That is respondent number 4. Respondent number 4 also filed their affidavit in opposition where they have said that though petitioners claim that amount of 50 lakhs something, after page of the record, it seems that the amount pending is 35 lakhs 71,780. That is the amount as per respondent 4. That is the amount that has been due to it. And it has been also been written in the affidavit of opposition that they are writing several letters to the CEO and the Election Commission of India, and they are not being they have received the fund. As this, I have made the instruction on it. This is communication. This is the amount that has been disbursed by the office of the election.
No, what you tell me what do you want to say?
No, sir, the amount has been due. My then
The amount has been disbursed.
Yes, right. District election officer generally they give us the fund that is required, not against a specific contractor, but as well as generally for this financial year will be requiring this amount of fund. Then accordingly, on the basis of that allocation, we give the election commission of India release the fund to the concerned district election officer, and they accordingly disburse the fund to the concerned contractors, whoever what amount is due. And suppose they require a fund of 23 lakhs, and if the budget is of 10 lakhs, if 10 lakhs is given to them, then equally it should be proportionally divided among all the contractors. So, and if you honor will see the first that letter of 23 February 2024, it could be seen on for financial year 2019 to 2024. Altogether an amount of 7
Yes, yes. What is this? You're not. Where have you asked for the funds? Have you asked for the funds?
Yes.
Where have you asked for the funds?
In the affidavit, they have given a letter on even page number 10 of affidavit. Requirement of additional fund. There is up to last letter is of 2019.
Have you submitted any affidavit?
No.
You submitted an affidavit.
Lordship, my lordship, I dispose of the matter because if
How will I dispose it of?
because respondent number 4 are the person who the authority they are issuing the work order. CEO has no role in that. What amount they will have budget that is requested are allotted by the CEO.
So if they are admitting that he is.
Why have you given work orders, when you don't have the money?
No, fund has to be released from the.
Why? Under what head? Under what head? When you issued the work order, did you take the permission of the CEO that we are issuing this work order, you have to give the fund?
Work order has been issued in pursuant to the election duty.
Maybe in pursuant to whatever duty.
From their communication.
It's the council, you see, that is not the way the government functions. Government gets a certain budget. Then you use the budget as you deem it proper. It's not that you use whatever money and then you go and ask the government, I've used this much, please give me this much. That's not the way it does. That's not the way the government
I
functions.
take specific instruction on the communication of the election commission of India.
What?
Whether the petitioner money has been disbursed or not.
It has not been disbursed, that's why he has come.
Then they admitted these are the amount because of the
You
fund.
have admitted that, you have admitted that 35 lakhs you owe. Your only case is that the chief election.
Para 8 my lord, that fund is yet to be allocated, but balance amount of the pension is not connected.
Then also it can be disposed of because it is the admitted amount, 35 lakhs something.
Para 8 of their affidavit, they have written that we got the statement made in paragraph 8, the writ petitioner different back to state that the government in election department has already been moved for fund for making payment of the balance amount of the petitioner along with his other fund. So that is their matter. They have admitted, my lord, because they have written to return for fund, they say.
And my submission, the CEO office is regularly providing fund in each financial year. In fact, from 19 to 2024, an amount of 7 crore 75 lakhs 2,081 rupees.
You want to say that, my lord, we have given not particular.
I know, we have given everything.
There is that.
So I think,
Now they are
how much have you given?
for total from 2019 to 2024, Your Honor, the amount.
2019.
2019, when because I have collected data from the year when this petition is filed.
Can you give, is it the affidavit?
No, it's a.
You see, what you can do, you can give an affidavit.
That will be better, man.
You give an affidavit, then we will ask them to account for that entire amount. And then we'll tell them to account for the entire amount. Then they will see.
Find the affidavit in the.
Yes,
I
yes.
also seek instruction.
Yes, right. Mr. Yes, what is the name? Eh? AI Ali, Learned Council for the
Response number 5.
respond number 5.
I went
Submits that budget, no, submits that money is always provided to the state government,
The district election officer Kamrup.
to a district election officer.
Time and again.
You know, as and when they ask for the same. Full stop. He submits that from the year 2019. Yes, this way.
Yes, sir.
From the year
I am giving the record from 2019, Your Honor.
from the year 2019 till
2024,
2024,
an amount of 7 crore 75 lakhs
an amount of 7 crore 75 lakhs
2081.
2081 has been provided to the district election officer, Kamrup. Full stop. Mr. So shall submit an affidavit in that regard. Full stop. Mr. S.R. Barwa, appearing for the district election officer, shall give an up-to-date account in the manner in which he has used up 7 crore 75 lakhs till date. And as to on what basis the work orders / supply orders had been issued to the petitioner. The affidavit shall be filed by the district election officer also within the
2 weeks time.
respondent numbers
Response number 2 and 5.
2 and 5, and you are
1, 3, 4.
district election officer. Who is the district election officer? You, not you, which respondent?
Response number 4.
4 months.
The respondent number 2 and 4.
No, 2 and 5. I am agreeing. He's 4. 1
I
and
know, but who is going to file your
I am
affidavit?
filing on behalf of 2 and 5 here.
The affidavit to be filed by the respondents number 2 and 5 on the one side, and the respondent number 4 on the other should be submitted within 2 weeks. This is the matter.
Published.
Mr. S.R. Barua, please take it seriously.
Yes, yes, Lord.
Otherwise, I'm going to call him now.
Lord, Lord.
For 7 crores, 7 lakhs, 75 lakhs, you have to give the, how you spent it.
Lord.
Yes. Item?
20.
Yes. What is the
My lord, this matter pertaining to settlement of Sand Mahal, my lord.
settlement of San Mahal?
Live auction took place, my lord.
Huh?
Live auction took place, my lord.
Live auction.
Live auction. My lord. Live auction started, my lord. At 11 AM, my lord.
Huh?
At 11 AM. My lord.
Then
Yes, my lord. My lord,
this settlement is for how long?
for 7 years. My lord, when the live auction was 125 to 130, my lord, it was for 5 minutes, my lord. 3 bids were placed, my lord. One by the petitioner, one by the respondent number 7, and another by another person, my lord. Then it goes to another extension, my lord, for a period of 5 minutes, my lord. 131 to 135, my lord. Yes, my lord. But within a moment, my lord, within 1 minute, my lord, the live auction was conducted by respondent number 6, my lord. It appeared displayed in the computer that respondent number 7 has been declared as highest bidder. Auction closed. My lord, kindly annexure 5, my lord, of my reply.
Page?
Page 42, my lord.
Yes.
Yes, my lord, your lordship will find left side, my lord. Server time 133, 1 is to 33 is to
Page
30.
42?
Page 42 of my reply affidavit, my lord.
Mr. Counsel, I'm going to go with my file. You go with your file. We're never going to meet them.
At the last.
My pagination is 42 is here. This is my page 42. Your page 42. You see, this cannot, you have got to paginate your page as per the court record. Or should I come down and take your pagination?
My lord, only one annexure, my lord, there is. That is the,
Maybe that one, but which page?
sorry, my lord.
You have got to follow the court pagination.
After, my lord.
Huh? You write your own order then. I don't have any 42.
Annexure 5, my lord. With my reply affidavit, my lord. Only annexure, my lord. Coloring page, my lord.
Yes,
Yes, my lord.
47. This is 47, not 42. Oh.
Yes, my lord. Your lordship will find, my lord, left side, my lord. Server time 133:31, my lord. Here,
Yes.
my lord. Here, bottom, my lord. Last bid place time, my lord. 13:29:59 second, my lord. And my lord, next, my lord, middle portion, your lordship will find auction ended. Highest bid as of now in rupees 2,62,45,000, my lord.
Where? Auction ended. Where does it say auction ended? At the bottom.
Yes, my lord.
Auction ended.
Auction ended.
But when did it end?
My lord, then my lord, kindly see system time 1:33.
Where?
And the above, my lord.
Huh?
Above, my lord.
Above.
This is
Okay. Auction end. 24th is 12 o'clock.
no, my lord. Your system time 1:33.
Your system time 1:33:31. Yes.
31. Yes, my lord. And my lord, it was for 1:30 to 1:35 PM, my lord. In the midway, it was closed, my lord, declaring the respondent number 7 as highest bidder, my lord. This is my only case. Because it was for a period of 5 minutes, my lord.
it should have continued to till 1:35 p.m., my lord. But after starting, my lord, immediately it was closed, saying that, showing that
So it was till 1:35, in 5 minutes.
no, it was for 5 minutes, but it was closed, ended on 1:33.33 p.m., my lord.
1:33 point,
33 p.m., my lord. Where the petitioner,
where did you get 1:33?
your system time, my lord. Petitioner took the screenshot, my lord.
Your system time, 1:33.
Yes, my lord. When system time was 1:33, it was shown as petitioner number, respondent number 7 was declared as highest bidder, my lord.
Yes.
Well, the same document shows my lord, auction time was from 1:30 to 1:35. And my lord, the allegation is raised, my lord, against MTRO, basically. The agency which conducts, my lord, the agency is refuted allegations, my lord, because it is the same agency in which, my lord, he participated technical bid, my lord. He was allowed. And in the same bid, my lord, he has come and MTRO has filed affidavit also, my lord. The agency, my lord,
The agency who
which conducted, my lord.
conducted
There is
the,
no, my lord,
the
agency-
auction.
Yes, my lord.
There was a nexus between the respondent number 6 and 7, my lord, where this auction was staged by this honorable. This honorable court himself said that this is not a single isolated case. Such type of cases are coming frequently, my lord.
So that is, whether it's coming frequently or
No, no,
infrequently,
no.
that's a different issue.
Yes, my lord.
How do we know that this the auction time was supposed to be for 5 minutes and it didn't take place for 5 minutes? How do we prove that? Yes,
It might be very difficult, but we have nothing. I'm sorry.
yes.
We have stated in our affidavit, page 28, about affidavit.
Affidavit
Affidavit. Affidavit in opposition.
of respondent number 5,
6.
6.
We have also next document in 33.
Yes.
The normal time for the live auction was
Which page, which para? That's the
paragraph 6.
paragraph 6, yes.
So no, according to the system, normal time for the live auction is 60 minutes duration. Thereafter, it got
60 minutes duration.
60, initially it was for 60 minutes. Then if the computer goes to 2 and more bits than receives in system, then it got automatically extended by 5 minutes. And it's so on. That during this period, if 2 or more bits are received by the system, the auction will get extended by 5 minutes. And during this, if 2 or more bits are again received, the system again gets extended for another 5 minutes and so on. The highest initial price offer amongst the technically perfect bidders shall be the floor price. Price and live auction and the qualified bidders have to submit their final offer price greater than the floor price. Final price offer to be received by the additional number not less than 1% of the reserve price. It is 1,45,000. And the highest final price offer to be decided by the preferred bidder on the conclusion of the auction. And final bid was put on 13.34.53 paragraph 7 or 6. We have also annexed.
Acha, the live auction started from 11 o'clock.
11 o'clock. Initially, there was no time constraint in first 1 hour. Thereafter, it got extended by 5 minutes. Normal. And in last minute, the restaurant number 7 has participated in that, and in 1 hour 34 minutes 56 seconds. And the petitioner did not participate in the system and then what closed.
Petitioner
Okay.
did not participate.
Because on that occasion, he did not put his bid on last moment. We have already annexed
He did not put it in the last moment. So which moment did he put it in? The first moment, second moment, what?
We have already annexed in our annexation. Lordship.
I don't understand. Ma'am.
Page 33.
Well, the petitioner participated. The system says, well, once a new time frame is 1 hour.
Yes,
But well, if somebody rebids, madam, if you have more
yes,
high,
I bid.
it gets extended by 5 minutes to 5 minutes.
Okay,
So
okay.
he wants to say that the petitioner, madam, it is his own fault. On the last minute, he didn't reoffer, madam. He didn't increase his price. That led to his disqualification.
Let me, disqualification, where is the
But
question?
because that stock, his figure, he didn't increase his price, somebody else came, the respondent of 7 offer higher price than that. And he had a window of 5 minutes, within that 5 minutes, he didn't,
Okay, within that 5 minutes,
Yes,
he has to,
yes.
uh,
he has to offer his price.
or he has to, okay,
Offer his price. Higher than the.
higher
price
than
offer.
that last.
Then
bid.
again 5 minutes goes.
Then my lord, when
And somewhere
when
it
this
has,
screenshot was taken, my
Just a
lord.
minute, just a minute, one minute.
and somewhere it has to be stopped. And the system is stopped on 1 hour 34 minutes 56 seconds. We have given detail of live auction details in page 33 also. Altogether 20. On 81 occasions.
Huh?
Bids were given. 81 occasions bids were given. On
What?
altogether.
What?
Total of bids were purchased 81.
Total number of bids were 81.
81 by
Okay.
different bidders.
Ah,
And finally, the respondent number 7 got selected, Karannath.
now where is the petitioner in page 33?
Page 30, he is number 2, that's it.
What is his name?
Najimuddin Laskar.
And number 7?
Karannath. He is number 1.
So Nazim Uddin Laskar,
Yes.
there is one thing is called out here, transaction time. 3:30, 1:29.
129.
That means 1:30 in a way. So 1:30 he gave. Then where is this Karannath?
Karannath is on top of the list.
Wow, so he gave it 1:34.
134. Thereafter, no bid.
No, but then you have got to wait for 5 minutes. No.
Now, 5 minutes ends on 35, 135. In the meantime, they did not participate. Huh? In this 5 minutes block, they did not participate. They did not put his bid. In last minute.
But within a minute, my lord, they closed the auction, my lord. It is very much.
No.
System is automated lordship.
You are not making sense. Please try to understand. Please, you see, if you have got to try to make me understand. Okay. Please come to page 33. Come to number 1.
Number
Karannath. Before bid amount, bid offered 2.6. When did he offer this amount of 2 crore 62? 45. When did he offer?
1 hour 34 minutes 56 seconds.
So he offered, if he offered at 1 hour 34 minutes 56 seconds, don't you have to wait for 5 minutes for some others to take? Yes,
Lordship, after 1:30, the time was extended for another 5 minutes.
correct.
In between those 5 minutes, I am representing respondent.
Ah.
I participated.
Uh-huh.
So the time was in between 1:30 to 1:35.
Okay.
In between 1:30 to 1:35, I only participate as per the.
Uh-huh.
I was with the winning bidder. Because if 2 minutes come in,
Uh,
it will move from 1:35 to 1:40 for another 5 minutes.
Okay,
Since there
okay.
were only one bidder,
okay.
it ended. This is the case why my learned friend want to protect.
No, Mr. Council, but when did you give your last bid? What time did you give your last bid?
1:34 minutes 56 seconds.
So you gave your, please, please wait. Please listen. Within time what? What is that? That is not my question. My question is, you gave your bid at 1 o'clock 34 minutes, correct? Supposing you give your bid at 1 for 34 minutes, now don't you have to wait for others to bid for that also? No, that's not the way it functions.
The extended slave of 5 minutes,
Okay,
anyone can bid.
anyone can bid.
At that.
So that means the last bid,
I was the
since,
only bidder.
no, since the second last bid had been made at 1 o'clock 30 minutes, say 29.59, say 1 hour, 1:30. So 5 minutes slot was extended for persons to put their bid. So in that 5 minute slot, now supposing you give your bid and you gave your bid on the 34th minute. 34 minutes, 56 seconds. Just 4 seconds away from the next. That's if supposing so then if you give your bid, isn't chance given to some others to give a higher bid than that? Or how does it suddenly end straight away?
He had to, Lordship.
I don't understand this concept.
Lordship, he had to put his bid on within
Huh?
4 seconds.
Huh?
Lordship, he will get time only 4 seconds because
4 seconds.
this is the trick of the tender process. We
He'll get-
already stated
He'll get only
Because-
4 seconds.
because the petitioner, he also put his bid in on only last moment. Lordship, kindly turn to.
No, Mr. Council, you see, that is the trick. Now, you see, that is not, no, please understand. If you go by the logic you're saying, he had given his bid at 1 hour, 1 o'clock, 29 minutes, 59 seconds. Acha, but there were others also.
On there were others
Karan Nath
that,
also
that,
was.
that moment, sir. And the petitioner used to put his bid in only in last moment. In serial number 5 itself, Lordship might say, understand that he has put his bid on 1 hour, 24 minutes, 59 seconds. Always he
So,
used to put it
so
in
that
last
trick
minute.
is there on the last bit.
That-
Okay.
that is trick.
Okay.
That-
in the year 2022. And respondent of subject 7 is a boy. He has already intended to some other business. So he, because of the pendency of this, he do not want to continue. He has already letter to the government to release it under money. But they said that since the rate is pending, they can.
Let this read be allowed, but one projection he has said that he is willing to offer 3 crores.
Yes.
More must be, let him, it be settled by this order, my lords. And cost should be imposed on both of them, my lords. Why? Because, my lord, because due to them, my lords, there is a loss to public exchequer, my lord, these 2 years, my lords. Now they have come.
They could have filed interlocutory application seeking vacation of this order.
It
is myself, my lord,
If this is the case, why we are just, lordship and me are just.
Lordship, I have offered 2 crores 62 lakhs. In the rate petition, they have projected that they want to offer 3 crores.
We'll take that 3 crores.
Yes, paragraph 9 is very clear. In the additional reply also, they have reiterated that.
Okay, then you release their earnest money.
Will release, my lordship will pass an order and his 3 crores may be recorded.
Yes.
That's all, my lords. Otherwise, I had judgments.
But interesting, I learned that this new way of
Yes, because
auction.
there has to be stock because somehow because. it
But
will
this is a very dangerous thing. If you give when you give your bid on the 59th second, just 1 second away, or say on the 60th second, then there's no chance for the other side to give to come in anyway.
Perhaps there is a apparatus in place, otherwise this bid will go on perpetuity.
Anyway, all's well that ends well. Heard, mister?
AHMR Chaudhary.
Huh?
AHMR Chaudhary.
AHMR Chaudhary. Just just give your full name.
Abul Hakam Muhammad Rizwan Chaudhary.
Have you got an Indian passport? Only 3 names I think are allowed. It'll be a big problem. Okay, right. Heard Mr. HMR Chaudhary, learned counsel for the petitioner. Also heard Mr. No, not you. First.
D. Gogoi, my lord.
D. Gogoi for the Forest Department.
Forest Department.
This one, K Gupta.
You have respond number? Okay, respond Mr.
K Gupta.
K. Gupta for respond number 6. And Mr. J. G. Khandelia for respond number 7. The petitioner is aggrieved. So you have been settled the tender or no? Only the letter of acceptance. Letter of acceptance issued or what? Nothing. Nothing. Then what have you challenged?
No, my lord. Yes,
Challenge because
my lord.
you are not allowed to give your bid.
Yes, yes.
Okay. The petitioner had taken part. The petitioner's case is that he had taken part in the e-auction sale notice under so and so, so and so, so and so. Under NIT number so and so, NIT number so and so, dated 8/11/2021, relating to Katakhal Sand Mining Contract Unit -1. The petitioner as well as the respondent number 7 being successful in the technical bid evaluation stage participated in the final bid evaluation stage on 24/3/2022, 2022, by participating in a live auction conducted by the respondent number 6. Next paragraph. The petitioner's grievances that during the live auction, when the petitioner had already offered the bid price of 2,61,000 and the respondent number 7 had offered rupees 2,62,000. Is it? No. No, it will be, sorry, it will be 2,61,50. 50. And the respondent had offered rupees 2,62,50 for the Sand Mahal. The live auction abruptly came to an end, thereby denying the petitioner an opportunity to offer his next bid. The live auction details, which was captured by the petitioner through his mobile phone, showed that the auction had ended with the respondent number 7 being declared as the winning bidder at his quoted rate of rupees 2,62,050. Being aggrieved, the petitioner has filed the present petition stating that the live auction had been abruptly closed to enable the respondent number 7 to be settled with the Sand Mahal. Next para. The petitioner's counsel submits that the alleged abrupt closure just 2 minutes. Okay. The alleged abrupt closure of the live auction. No, just read a little before that. I've forgotten what. Next higher bid. had been done due to a nexus between the respondent number 6 and 7. He also submits upon instructions that the petitioner is willing to offer up to rupees 3 crores for the said Katakal sand mining contract unit -1 in terms of the e-auction sale notice under NIT number HKD/DFO bracket T bracket close E dash tender /09 dated 8/11/2021. Next para. At this stage, Mr. G. Khandale, learned counsel appearing for the respondent number 7, submits that the respondent number 7 would like to withdraw from the bidding process pursuant to the e-auction sale notice under NIT dated 8/11/2021. He submits that the Sand Mahal may be settled with the petitioner as the petitioner has offered rupees 3 crores for the Sand Mahal. Next, Mr. D. Gogoi, the learned counsel for the Forest Department, submits that in view of the changed circumstances and the submissions made by the counsel for the parties, the Forest Department will settle will consider settling the Sand Mahal with the petitioner at his offered bid price of rupees 3 crores. That's all. Next para. In view of the change facts and circumstances of the case, there is nothing left to adjudicate in this case. The Forest Department shall accordingly consider the case of the petitioner for settling the said Katakal sand mining contract unit number 1 with the petitioner at his offered price of rupees 3 crores. The respondent shall also allow the respondent number 7 to withdraw from the bidding process and return him all his earnest money. And return him his earnest money. The writ petition is accordingly disposed of. Hold it.
It relates to non-payment.
Acha, one thing, Mr. Gogoi, it will be for the remaining part of the 7 years or what?
Will be 5 years. 2 years is gone. 5 years.
No, my lord, 2 years gone, my lord. No. Then 30,
No, my lord.
32 lakh,
It will
32 lakh
be
extra, my lord.
See, my lords. It will be 5 years only. It's up to him. It is his own risk now.
Yes, because that's
Yes.
up to him.
Yes.
Now, in that regard, my lord, petitioner will be pleaded. My lord, kindly see, he is offering
No, my lord.
32
Then
lakh
it
extra,
will not be 7 years, my lord. It
Yeah, why
has to be 5 years. 2 years is gone.
No, but then anyway, that amount that he had offered earlier, 260, that is for 7 years now.
Oh, yes, 7 years.
So it cannot be for 7 years.
Right.
The 3 crores will be for 5 years only. I mean, proportionately you have to calculate. He's not offering 3 crores for 5 years. He's offering 3 crores for 7 years.
Yes, my lord.
Different is here.
No, you should be fair also. You cannot be unfair.
Then, my lords,
Because you see, his bid, now, what have I said? No, whatever. That last para, just read.
7 no. 7 it will be extension of your.
3 crores, full stop. If you, whatever, No, full stop, full stop. The forest department shall tree growth for 7 years, or in the alternative, to um, to make a proportionate,
That can be done.
to make a
Extension won't be given, my lord.
to make to make a proportionate to make a proportionate what
Adjustment.
to make a proportionate adjustment for the remaining part of the contract period.
That can be done.
It relates to kind of non-payment of contractual fees.
Lordship, here also, Ministry of Jal Shakti is a necessary party. Jal Shakti.
Jal?
Shakti.
There is, otherwise the admission is there by
Yes,
the,
Lordship, yes.
so
It's an
you just
action.
do one thing. That's what we have been doing. You just add this Jal Shakti as a party.
Yes.
Either you make an amendment of the writ petition, or you withdraw with liberty to file afresh, whatever you choose.
We will want to include my lord, Jal Shakti, my lord, as the.
And you file an application if you want to.
Yes, yes.
It take longer for him, but it's his choice. On the prayer, the petitions council lists the matter after 2 weeks.
2 weeks. Keep your best.
24.
No, in this case, we have filed an implement application for including certain other persons as co-petitioners.
Item 24.
Item 24.
We have not received the copy of the IE.
No, it's not here, not listed.
No, that IA is not listed today. We have filed it today.
Okay, so what do you want to do?
Lordship may take, fix it on some of the.
My lord, even though this petition does not have maintainability issues there, I'll just point out two things, my lord.
No,
The first thing,
on
no, let me,
maintainability only I am filing.
no,
the
let
IA.
me,
Well,
I don't know why he does not, just let me submit, my lord. My lord,
Let him submit whatever he wants to submit.
my lord, look at the prayer says that name appear, to restore, page 26, my lord.
Yes.
That should not be issued a direct and restored electricity of the above named 19 members whose names appear in the paragraph 11 to bring on record the outcome of the inquiry if done against the respondent number 4. So first he wants, as a two petitioners, he wants to have a restoration connection of 11 other person. And now he wants APDCL, an authority, to inquire into a franchisee with whom our relationship is already broken. So now how can we conduct an inquiry against the franchise? He has an alternate remedy to go to under CGRF as a consumer. He may go there if he has anything dispute with the franchisee, not with us. Our relationship with the APDC, with the respondent number 4, who was a franchisee, is already broken. I have a proper instruction regarding that. So how would the REIT code now give a direction with a thing which is already expired, my lord? My lord, I have a the private party, private franchisee, my lord.
This is one petitioner. How many petitioners are here?
Two petitioners.
Initially, there were 2 petitioners. Because of the maintainability issue, I want to restrict the relief to 13 petitioners. I want to include 11 more as co-petitioners. That is why, and for amending the petition, I am filing the IA. Let the IA be listed, whatever is the decision. If it is to be rejected on merits, it will be rejected. That's the.
My lord, my lord's own judgment is there. I have heard my lord has said that you cannot amend your prayer by bringing more petitions. He either withdraws this and file a fresh. My lord's own judgment is there. I don't have the
Lordship,
copy.
if I may suggest, Lordship will fix it on 9th of April. Let the learned senior counsel appearing for the petitioners appear and submit, and all the submissions can be entertained. Let it be fixed on 9th of April.
Who is the senior counsel?
SK Singh.
He's from where?
He's from Tesco. Let him appear and submit. Lordships will decide on that. If it is not maintainable, let it be rejected.
You are taking electricity from the respondent number 4.
No, yes, he was a franchisee of the APDCL.
Oh.
So there was the entire case is that at that point of time, there used to be something called a franchising system under the DTR. And this person indulged in a lot of misdeeds and took money from people for giving the connections. Now, ultimately, what happened, Manoj, all these persons, whether these two petitioners or those we are proposing to bring, they are below poverty line persons. They are someone is having one fan or two lights in the home. They do not even have luxury to charge the mobile phone also. So Manoj, these petitioners Manoj, were served and lot of villagers were solved inflated bills. And most of the dues pertain to the period when the respondent number 4 franchisee was operating the business. But we do not claim anything special from APDCL. The only issue was that his franchisee agreement was terminated on the basis of complaints made by us.
So what do you want?
Well, we only wanted that the inquiry should be, because there was in fact, there was an inquiry done to our knowledge against the respondent number 4. Respondent number 4 is also a party in this petition.
No. This court is inquiry done for what purpose?
Well, because the franchisee agreement between the APDCL and this respondent number 4 was terminated because of the malpractices. Lot of malpractices.
So what do you want against? So what is your relief plea?
The relief plea is that the dues that had accumulated during the period when he was the franchisee, those dues should be adjusted, Manoj.
Why?
Because Manoj, those dues are inflated dues. For example, if I am to serve,
Is there an alternative remedy available?
Yes, Manoj, there is CGR, Consumer Grievance Redressal Forum, that is specially enacted by APDCL in 2019, where in all the consumers, or the present consumers, if any with regard to the bill or any accountability with the bill may go there. So there is an alternative remedy available.
And that's with regard to these issues.
Issues. And this is there.
These are questions of fact involved.
Yes, there's a fact involved. There's a district in every district of it.
The consumer grievance forum cannot go into the issue of what happened during the franchisee agreement when the franchisee was operating. Those questions cannot be inquired. That can only be inquired because these are technical matters. Only they have the records.
If they are technical matters, do you think this High Court is equipped for it?
I'm not submitting on that. The issue is here, whether the respondent number 4 during his duration, because there is other pending litigation between them and the respondent number 4 as of today in this High Court matter.
Sure.
And because the entire dues of the respondent number 4 were not cleared due to certain reasons by the APDCL. So there is a lot that is going behind the scene.
You see, dues of the respondent number 4 not being cleared by APDCL is not the issue here.
No,
in
not
this
the
case.
issue here, but because of these complaints only, these malpractices only, his security amount and some other deposits, they were held up by the APDCL, because of which he approached and even filed a contempt petition. But I don't want to submit today on merits on this issue.
If you don't want to submit, but this court wants to know. We cannot dispose of a case according to your whims and your
I
dislikes.
didn't say that, I am only submitting that this matter. I have filed an IA. It may be not, having any merit. Let it come up on 9th. Let the matter be heard and let him file whatever objection he has.
First, you have got to say, you have got to convince this court that you have got a case. Then only we'll think about that.
Let the IA come, Let the IA.
Why? Why should I wait for the IA? Why not now?
Lordship will then list it for on 9th, let the senior counsel come.
Why not? Why 9? Why 9?
Because other matters are also fixed on that. If your Lordship insists on 27, 28 of March.
Why not next week?
Let it be on 27th.
Why not next week?
No, next week I cannot argue this matter.
Your senior is going to come, not you.
No,
Your senior from Tezpur or whoever is going to come. You're not going to be here.
On 27th, then he will come and he will argue.
Right. The counsel for the petitioner, Miss. Have you given a vakalat here?
Yes, I want to.
You're here.
Yes, we have submitted for the writ petition also and for the fresh IA also. Separate vakalat has been filed.
27.
27 or 28, as the Lordship pleases.
calculated.
Otherwise on 9th.
Second.
Second.
Right, leave this matter on second.
Lordship will have it on 9th. Second.
May I have the instruction with me? I submitted as well.
Leave this matter on second. Now, first off, we write, though the petitioner's counsel had prayed that the matter be listed on 9th, this court is not agreeable to the suggestion. Accordingly, leave this matter on second.
25.
Right, please. Your Lordship, we seek for some time to reply the IO filed by the excise.
Item?
25. Keep well, Lordship.
Okay, Mr.
Yes, Your Lordship.
Yes,
Nandi,
Nandi is granted. How much time?
2 weeks.
2 weeks time to file affidavit in reply. This is the matter. Huh?
I applied for response number 6, my lord.
Yeah.
We have filed our wakalat now. It is
Okay.
been checked. Now
Yeah.
they will also be not shown in the list.
Okay. Mr.
D Das on behalf of H. Chamua.
Appearing for?
H. Chamua, response number 6, appearing for 6. Atigaon Samiliti.
Mr. D.
D Das.
In item 25,
Yes, my.
Mr. D. Das.
On
Senior
behalf-
counsel.
No, my lord, on behalf of H. Chamua.
He is D Das. He appears on behalf of H. Chamua.
So what do you want?
He wants his name to be shown.
Shown in the.
Oh, you want the name to be shown?
Oh.
Mr. D. Das, appearing on behalf of Mr. H. Chamal and counsel for the point number 6, is also present. Okay. Do you want to file affidavit? Have you filed? Have you filed affidavit?
No, my lord, we are newly engaged, my lord, we have just filed our wakalat now.
Is granted, is granted 2 weeks time to file affidavit in the position.
Item 29.
Thanks, Your Lordship. Lordship, this matter is led by my senior K. Chaudhary. Due to some personal difficulties, he has left for early today, Lordship. So Lordship kindly accommodate only for today, Lordship.
On first week of April, Lordship.
Lordship, no, Lordship, 20 March, Lordship, next. week,
When?
20 March.
Nothing will happen, Lordship. Already
20
notice is
No, 20 March, so we've got too many cases.
3rd of April, Lordship. 3rd or 2nd or April.
2nd April, Lordship.
Okay. Right, on the prayer, the party says the matter of second April.
Surprise.
Orders.
Yeah, please, my lord, the order has been complied with, my lord.
Yes, madam, complied with?
Lordship, 2 weeks time maybe given.
Please read 2 weeks time. What do you mean 2 weeks time? Read that. Tell me what you understand by it,
Lordship, may I read?
please.
In compliance of the Honorable High Court order dated 6/12/19 passed in WPC number 3149/2016, representation submitted by the read petitioners, that is representation dated 13/5/2015, submitted by Miss Salema Khatun, Secretary Jania Anchalik Mahila Poultry and Dusari Cooperative Society, and representation date 15/11/2015, submitted by Abdul Jalil Talukdar, President of the Multipurpose Technological Institution of All Religious Philosophical Education Society and Trust, was examined and following decisions were taken. Number 1, regarding the site of first set of scheme namely land development at Jania Gramin Vikas Multipurpose Technological Institution and All Religious Philosophical Education Society and Trust, Assam at Jania Bazar. The then BDO Mandya Development Block submitted status of feasibility report of height letter number so 2021 dated 10/2/2022, along with the reported of concerned technical person to the then project director, DRDA, Borpeta. As per the report, concerned technical person, accredited engineer, uh, physical verified the purpose scheme site and reported that the site is already filled up with earth, and there is no scope to take new schemes for earth filing under MGNR ERGA. It has been clearly stated in the said report that the first scheme is not feasible in the proposed site. The video Mondia Development Block also stated the same fact in his another letter submitted by number 21/22/50/1159 dated 01/11/22. Hereby he has stated that as reported by the aggregated engineer Zania GP, the location of the scheme, namely land development at Zania Gramin Vikas Multipurpose Technological Institution and or religious philosophical educational society and trust Assam at Zania Bazar, was already filled up with earth, and there is no any further scope for taking up new scheme for earth filing under Manrega. The institution has not any physical existence at present at that locations. Number 2. In person to a report submitted by the BDO, Mondia Development Block, basing on the physical verification and investigation made by the aggregated engineer of Zonia GP, the second set of scheme is visible.
Yes, Mr. Mahmood, you are there. I think it has been complied with.
Complied with what Madam said sometimes back that some persons are creating obstructions.
That is a different issue. The order has been complied with. Order has been complied with. Whether they are creating obstruction or that is not the issue.
No, complied means not only in paper, in practice, so I have to.
No, this contempt is between me, the court, not me, the court. And the respondent, not between you and anybody. It is between the court and thing. So I'm just informing you this. I don't have to wait for your permission.
No, I am not saying that. I am only saying instruction. So what is the latest development?
No, this what about the latest development? Now you see, once they have passed this order, if you are aggrieved with this order or something is happening, then you can come afraid. Contempt, in a contempt, we cannot make any observation, any direction. We are helpless.
Understand? We will also file another capital. There is no bar. We also can get challenging this. But thing is this, it is a very minor matter. Now, whether.
You have filed another case? You can file a case if you want.
Yes, then I can.
If you want, but there's nothing here to file. These are this your representation. Luckily, they have now accepted it.
They have accepted, but whether it is practically what is done or not.
That is a different issue. Third, Mr. M.U. Mohammed, learned counsel for the petitioner. Also heard Mr.
BK Dasman.
B.K. Das
For contempt number 1 and 2.
for the respondent number 1 and 2. The Mr. B.K. Das has submitted order number DRBT-2/HC/2014-15/1533 dated 26/2/2024. 26/2/2024, issued by the Project Director, District Rural Development Agency. I think the same shows that. No, the same shows that the order dated 6/12/2019 passed in WPC 3149/2016 at para 6 has been complied with. In that way of the matter, the contempt petition stands closed. The order dated 26/2/2024 is made a part of the record and marked as an exchange. Right. What do you want?
Lordship order has been complied with.
Only thing is also partly complied with, there is two part in the order. Lordship of Kandy City pays 12 vote order.
It's true. Yes,
Okay, in these circumstances, we are of the view that petitioners claim similarly with the other fisheries as contained in the order to the demand. If similarly actually does exist, it would be the case of the discrimination against the petitioner. An interest of justice would be met if the managing director of Assam Fishery Development Corporation Limited looks into the grievances of the petitioner as to whether there was late settlement of the case, and also if yes, to pass reason order giving the same relief. Now reason order has been passed, giving the relief has not been given. Now said the similar situated, but relief, that is this adjustment that is not been done. Now they have said parity.
In parity, we will go, as in parity,
Now
it
relief,
implies that we will
get
get
the
the
relief,
relief.
Lordship.
It implies that we are, reason order is there. and we are
Because
going
this
to-
order has been passed in two thousand twenty-one. It is part on 2021,
Yeah.
2021. Now Lordship 2024, and 3 years has left. After that, they have passed an order that is a parity. Parity is already there. In the para 5, there is a order of parity is already there.
no, what was the claim? That the settlement of fishery?
No,
Look,
Lordship, there is the same cases which we are getting these days, Lordship, get of position, Lordship. Regarding get of position, Lordship. Actually, this management has taken a decision around 6 months, 7 months ago. Earlier, lots of mismanagement were there in the ABC, Lordship. Here, what has happened, we have taken a stand that we will give all the, this content was earlier managing director. This managing director was implemented later on, Lordship. Yes, Lordship. Here we have taken a decision that we will give all these fisheries where there is a late settlement. We are giving Lordship, we will give Lordship in this case also, but where
You'll give what?
to them, but you in late settlement.
Late settlement.
But for let's say the amount we will refund them.
Yeah, you'll refund the amount.
Money here, Lordship, above 25,000, managing director cannot give Lordship. So they have to take the approval of the managing director. That is a normal procedure. Here, Lordship, here specifically, moreover, in the matter replacement for approval, only for approval. In parity means we are giving the Lordship. With the account front, we are but checking the account, we will pay the amount. Reason in the last part of the order, Lordship, if Lordship goes for the purpose, the petitioner to file a fresh representation indicating the actual factual circumstances of belated settlement. And upon the representation being submitted, the managing director
Where are you reading?
in the order, Lordship.
Oh.
From the order, original order.
Please tell me where you're reading, otherwise I get lost. They're giving me a document
no,
and they're reading from somewhere.
Lordship. In the
Yes,
main order, Lordship.
yes,
Last
Where?
part, last paragraph.
yes. Yes,
For the purpose, the petitioner to file a fresh representation indicating the factual circumstances of belated settlement, and upon the representation being submitted, the MD, managing director, to pass a revision order with a period of 4 weeks thereof, all the factual citizen of belated settlement be depicted in representation. So we have considered their application. So we have passed an order. That in that case, Lordship contempt, we have complied with the order of this honorable court. Lordship.
I have already explained. Parity is already there. They have said now parity.
Huh?
Parity, regarding parity, similarly situated person 14 LOT has been given the relief. If we are in the parity, we should be given the relief. Now, again, admitted that parity is there, but relief has not been given.
Really, we are asked to give a revision order.
So Lordship will close the matter after relief has been granted. Otherwise, Lordship, we have to approach again by filing a petition for the parity. Parity is already there.
what is the parity you want? Extension?
No, Lordship. Fact is like this, Lordship. They have invited a tender for settlement of fisheries
Yes.
along with some other.
Ah.
We have been allocated the fishery after some period, 4 months. We have to pay the revenue to the department. We have paid the revenue for the 4 months in advance.
Then they will give you back.
They have to relieve the amount, or they have to adjust the amount.
No, we will record his submission.
Lordship, my record.
That he'll pay you back. That's all.
Lordship, it is in the
Then Lordship, okay, Lordship.
Lordship, here I am saying on the basis of this order, Lordship.
Mr. Council, if you have given them late possession of the fishery, then you have got to refund them the amount for which they were not in possession.
Yeah, it will be given, Lordship, okay, that part is okay, Lordship. Yeah, I'm agree, Lordship, with the submission of my learned friend, Lordship. Here it is a contempt case, Lordship. In the contempt part, Lordship, we are being asked to give a dispose of the petition, whether they are in parity or not. Yes, the parity means they are.
No, I'm just recording your submission that it will be paid, that's all. Because as you have done in other cases, that's all.
In other cases, it was not contempt, Lordship, because in other cases, it was fresh repetition. There my submission is okay. This is contempt part. It is sure that we will pay, Lordship, because this order is there in the corrected part.
So it is sure, so we'll record what you're saying. It's like saying, it's like, saying everything, but saying that please don't record anything what I'm saying. What are you here for?
Yeah, recording, that's it. Record.
You're saying everything, you're saying everything, but saying, please dispose of, but don't record what I'm saying.
No, record. Lordship may record that we will pay after approval of the BOD direction. That may be recorded. That BOD approval, that may be recorded.
Okay, right. Heard Mr. S.K. Goswami, learned counsel for the petitioner, as well as Mr. P. Sharma, the learned counsel for the
Contempt.
contempt one, only one.
Two. Contempt number two.
For contender number two.
So because
Contender number two. What's up? For the respondent number two. The contempt petition has been filed for non-compliance of the order dated 12/1/2021, passed in WPC 78/2021, wherein it has been stated in paras 7 and 8 as follows, page 12. Next para. Mr. P. Sharma, the learned counsel for the respondent number two, submits that the order dated 12/1/2021, passed in WPC number 78 of 2021 has been complied with in view of the order dated 5/3/2024 issued by the Managing Director, Assam Fisheries Development Corporation Limited, Guwahati. Correct? And the corrigendum dated 14/3/24.
Yes.
He also submits that, as has been done in other cases, the petitioner would be repaid the amount of what?
Late settlement.
Huh?
Late settlement.
He'll be a pound, he'll be paid he'll be paid the bid amount.
No, late settlement.
Belated settlement.
He would be repaid the late settlement,
Belated amount.
the late settlement fee.
Refund.
He would be refunded, he would be refunded a part of his bid in view of the in view of possession of the fishery being given to him at a late stage, at a later date than what had been fixed. After getting the approval of the Board of Directors. Next para. In view of the above facts, the contempt petition stands closed. The order dated 5/3/24 passed by the Managing Director, and the corrigendum dated 14/3/2024 are made a part of the record and marked as Annexure X collectively.
May I correct one? Say one thing. Bid not, it is kissed money, Lordship.
Kissed money, not bid, kissed money.
Kissed money. Earlier part.
Refund of the kissed money. Well, what is that? What does it mean, kissed?
Kiss means initial stage, first installment.
Kiss is first installment. So there is no thing called second kiss.
All the installment we used to say kissed money.
Oh, then it's installment, not first.
My money, Lordship. This is my money, I have people.
Yes.
Lordship, may I submit one thing, Lordship? Though it is not a contempt jurisdiction. This order was passed in 2021. After 3 years, they have passed this paying order. Others have been paid, Lordship. Otherwise, they will keep it pending again, let's say 3 years.
No, it will not happen, Lordship. This thing there, everybody knows. Everything is.
You
now
come,
it
you
is-
come, you come in a writ.
Lordship will see in the.
You come in a writ,
Harassment of the client.
No.
come in a writ again.
Nothing will happen.
Your client will give you some extra fees,
Highly obliged, Lordship.
Not so big client. Also.
not so big. Yes.
They
And
are paying
so you take smaller fees
They
then,
are separating.
They are paying 76 lakhs rupees yearly.
huh?
They are paying us 76 lakhs yearly. His client.
Tell them to give you in the form of kind fish.
Oh my God.
In these three cases, my instruction is that in 5/10/2022, this amount of 2,54,000 these have been paid.
Paid.
That was paid.
Okay.
I have this. And in respect of contempt case number 508 and 509,
Yes.
it has not been paid, because fund has not, they have not received the fund.
Amount is so small, madam. That to madam,
Why don't you pay March?
only madam.
Just give, if you take some personal interest by just giving them a call, saying that you see this, just 2 weeks left for this financial year to end. I'm quite sure they've got some spare money somewhere.
But the SDO civil, he has very recently joined, just 1 week back. The earlier who has been made party here, he has been.
You go with a box of laddus or something like that.
Otherwise,
He has instructed me to pay for some time. The new person is up now.
only madam 1,47,000.
Yes.
I know, a small amount.
True.
And there was another
Because of,
2 lakh.
because of, they have a long list, in fact, not only this person. In fact, these are the persons. Only in contempt case, there are 3, but otherwise also some persons are there. Logic may keep it up.
Okay, right.
Since madam, direction is there, madam.
Huh?
Since the direction is there, so for
Yes, direction is there, they have already, requisition for fund, they have already requested, that we have annexed. In fact, the respondent number 1, some response from respondent number 1 has to come. I'm appealing for the respondent number 2,
So how much time did he ask you to give?
He has instructed me to pay for 4 weeks time.
4 weeks?
madam,
For what?
it will be too low. It is madam under medical.
That means you are not going to give this financial year.
But
It's ending this financial year.
they have not received the fund.
Financial, if they don't, you see, if they don't receive it now, they're not going to receive it for a few months.
In the next
It's not going to come.
budget only, if it comes.
Petitioner is also madam under medical treatment, madam. That
You
is
see,
why, madam,
right now is the time every department has got some spare money here.
But I spoke to him, I said that no fund has been received. But these are works under a special summary division of electoral roll and the panchayat election. The remaining works.
Panchayat election, madam, that
Yes.
is for the year 2012.
Yes, 12.
Madam, payment is pending.
Correct.
Government has no money for making payment. Only rupees 3.5 lakhs for 2 madam.
The SDO civil, he cannot pay from his own, because the work he has done for some other departments. Logic may,
Morning, after morning, madam, meanwhile, madam, the responsible ensure that we, as we get our payment.
he has instructed me to pay for 4 weeks time.
4 weeks means forget it for a few months.
But-
That is basically what he's saying.
But he has joined very recently. He is not even in the case. Even then, let's give us some time. I'll instruct them.
Let it be after 10 days, madam, meanwhile, madam.
Right. Mr. Dina, learned counsel for the respondents, please for some time. As the PDP, as the SDO,
Yes, ma'am.
as the SDO concerned has joined recently.
And 510 maybe good.
That's anyway. It's for 32 and 33, yeah.
Lodge.
List this matter again on New Year, so nothing will happen. That's the problem. List this matter again on 28. Just try and see if you can do something.
Lodge.
Because if he doesn't get it now,
That is one factor.
another 5-6 months is going to go.
So let's say, please to make an observation as regards to the giving a last chance matter.
This is a contempt, Mr. Counsel.
No,
Con-
this SDO.
This is a contempt
fact,
case. In a contempt case, we cannot give any direction or observation.
In fact, this SDO is not aware of this order. When I write the letter, then only he has got to know. In fact, if I go very technically, the petitioner has to give him a representation that this order is there, you comply. They have not given.
Okay, right, item for that item 34, you right? Mr. M.K. Sharma.
Right.
And Mr. Dinath, learned counsels for the party submit that the order has been complied with. So accordingly, the contempt petition stands closed.
Not. Problem. I'll try.
All right.
I am from contender number 1, madam. Contender number
That is, no one appears for the petition on call. Miss
PR Mohanto.
P.R. Mohanto appears for the
Contender number 1.
respondent number 1. This is the matter after
Any
3 weeks.
It's
For the time, I very slow respondent, that's not another 2 weeks time may be given, madam. To find out.
possibly a date may be given, because they have already taken their time in the month of December.
How much is the amount?
No, madam.
It's not about the amount, lordship.
This is not the amount. What
They
is
have
this?
not complied with the order dated 18/11 of 2020.
Page?
Page number 3, page number 11, and relevant portion is from page number 12.
To dispose of the presentation, madam, regarding madam shifting what one, madam, that,
Mr. Counsel, this is a 22.
yes, madam, but madam, madam, due to some madam communication gap, madam, it was not served properly, madam, that's why. So, madam, it is in the process, madam, within 2 weeks, we will take a decision, madam.
This is not done. This is nothing. This is not rocket science or anything. It's not even with regard to money or something.
Yes, madam, madam, by not properly served, and secondly, madam, some no confidence motion was, madam, issued against this madam contender, madam.
You see, there is no question of filing affidavit. This is it's only issue of taking a decision on the petition's representation.
Yes, madam, it is in the process, madam, and in the form of affidavit, we will file the compliance order. That's why, madam, I am submitting an affidavit within 2 weeks.
Okay, right. Heard, Miss
Yunanda.
Nanda, learned counsel for the petitioner. And Mr. A.K. Sharma, learned counsel for the sole respondent. The order dated 18/11/22 passed in WPC 7337/22 had directed the respondent number 3 to take a decision on the petitioner's representation dated 28/10/22 within a period of 1 week from the date of receipt of a certified copy of this order. Despite more than 2 years having passed, despite more than 1 year having passed, the respondent number 3, the respondent has still has not taken a decision on the petitioner's representation. this is matter next week. Give. This is matter next week. This is matter date. This is matter on 22nd. By which date? Instructions should have been received. Comma. Failure to obtain any instructions in this regard may entail the personal appearance of the respondent.
Much
22nd.
obliged.
You have everything ready, so it's just a small thing.
Positively, my lord, on 22nd.
May it please your lordship. Lordship of instructions are still awaited. Which will kindly grant us some time to obtain instructions and to file our affidavit.
Matter relates to non-payment of bill, your lordship. The amount of
Non-payment matter,
Yes, your
then,
lordship of instructions are awaited. Instructions.
what instruction? Say right. Miss
DJ.
DJ. Appearing for the respondent,
2, 3, and 4.
2, 3, and 4. Is granted
3 weeks.
3 weeks time to obtain instructions. This is the matter of two.
details.
My lord, in item 38 and 39, in both, while I am appearing for the first time. My lord, for as per number 1 and 3. So, my lord, my prayer would be let this matter may come up after 2 weeks, my lord.
Why?
We are contemplating, my lord. My lord, it's in process.
What's in process?
That verification and payment, my lord. So, my lord, by the end of this 31st March, they will be happy. The next time they come, my lord, that is why, my lord, I just want this. I will file. My lord,
Well,
was my lord, I never submit if I don't have any proper instruction, my lord.
hopefully.
Oh, my lord.
So on the next day, you bring a box of laddus
Yes, my lord.
in anticipation of you being happy.
My lord. That is what, my lord. So I will file and try to file my compliance order on the next date. So an affidavit.
The date may be fixed.
My lord will fix the matter after 31st March.
Okay, right. Mr. Ardhar, learned counsel for the respondents number 1 and 5.
1 and 3, my lord.
1 and 3. Submits that. Appraise that the matter may be listed on 6. Huh? Oh, 6. No, not 6. On 4th.
Right.
On 4th.
My lord, 4.
4th April.
My lord, my lord will fix the matter on 8.
On 8th April.
8, my lord.
8. Why 8?
So,
You said April. Now why you
Yes,
after 31st you said why are you changing a date?
just I have to get all these documents. my lord.
8th, you see that those 3 days is all going to be motion day.
My lord.
Just before Bihu, in the
5th, my lord.
5th.
Item 40.
Okay, right. Third, Mr. Sanjay Sharma, the petitioner in person, who submits that the order dated 5/2/2024 passed in WPC, in arbitration petition number. Huh? 16 of 2023 should be recalled and the case is not to file. He submits that he could not attend the court on time on that day. Mr. A.K. Datta, Leonard CG submit that he has got no objection with the application being condoned. To stop. I is accordingly allowed. Registry to. No, I is accordingly allowed. The order dated 5/2/2024 passed in arbitration petition number 16 of 23 is recalled. Registry to this arbitration petition number 16 of 23 after 2 weeks.
Please give me some fixed dates. I am petitioning in person, so I can't.
You're from where?
From Guwahati itself. If you give us a
Give a date.
second.
This case, Lordship was pleased to stay the operation of the interim order dated 25/9/23. We have served him, the private respondent was served with a dusty notice. Thereafter, he did not appear. Today also, he is not appear. So therefore, Lordship, he is not interested to execute the work. So therefore, Lordship, tomorrow there may be a declaration of general election. And if it is so, then model code of conduct will come into force. Therefore, Lordship may be pleased to direct the respondent to consider my prayer for issuance of the work.
I don't know. Let us see what he has to say.
Instruction, madam.
Let him up to instruction. How do you know?
But tomorrow, if the election is clear.
Then it is stayed. At least you've got a stay order in your favor.
Yes, Lord.
So then be
But
happy.
this is a public work, Lordship, because interest is lies, Lordship.
Your interest is not public. Your interest is private.
Lordship, because I am desirous to execute the work.
Your desire is, why don't you do it for free?
This is hardly, there will be some benefit, Lord. It is, otherwise it is a pro bono, Lord. And
Pro bono work.
what? I'll be executing pro bono.
This thing of file. The thicker the file, the higher the fee. The higher the voice, also the higher the fee. Yes, so what to do?
After 2 weeks, Lordship.
Huh?
Lordship will fix it after in the meantime and get the instruction.
Not correct. This says Bora. Learned counsel for the BTC. Is granted a further
2 weeks time.
2 weeks time to file affidavit in position. No one appears for the respondent number 5. Even though the additional affidavit filed by the petitioner on 20/02/2024 is to the effect that notice had been served by Dusty Service on the respondent number 5. On 20/02/24. Accordingly, notice deemed to be served upon the respondent number 5.
That observation, Lordship, has been in the earlier order.
Already said.
Yes, Lord.
Okay, that's not required then. That additional affidavit is not required, huh? Okay. No need. No. Okay, next, right. This is the matter, no one appears, that's all, just say that, no one appears for the respondent number 5. This is the matter after 2 weeks. Interim order to continue till the next week.
Possible date may continue because.
Due date. But why, no hurry actually. You've got to stay order in your favor.
The execution of work is of paramount importance. It is.
Let him get his information. Yeah, you're not telling us everything that you know. Okay, you give a date, when, you give a date on the 9th. List the matter on 9th for.
Please, Your Lordship. My learned friend was asked to produce the records, Malad. What happened was there was an NIT, Malad, on 2/1/12/2024, Malad. With regard to Malad, drainage work, Malad, in item number 42, Malad. Malad, my case is that, Malad, when the financial technical bids were open, Malad, I was qualified, Malad. But without, Malad, informing me, Malad, the financial bids were open, Malad, in my absence, Malad. And, Malad, the private respondent has been selected for the purpose, Malad, work, Malad. So I, Malad, alleged that there is, Malad, lack of transparency, Malad, also nullified, Malad, in trying to, Malad, manipulate the records, Malad. I've made the, Malad, the CEO of party, Malad, by name also, Malad. Lordship will find the NIT at page 28, Malad.
I have that account, Lordship.
Huh?
I have that account, Lordship.
Okay.
That's the allegation raised by him, Lordship. Is not correct, Lordship. There is no manipulation I can produce.
There is no?
No manipulation. of that.
Let him show, Malad, that we were present on that day when the bids were open,
There are
Malad.
two different aspects. One is on oath, he has submitted that there is a manipulation of his price bid. His price bid were manipulated and come lower so that others can be selected, Lordship. But I am showing, Lordship.
Malad, that I'm saying because, Malad, we were not, Malad,
I will
we were not called for,
counter
Malad, we are not called for, Malad, while the financial bids were open, Malad, we are not present, Malad. It was open in your absence, Malad.
No.
And it was specifically done, Malad, without informing us, Malad.
Lordship, I am
Let him
showing.
show, Malad, that was done, Malad, because as per the norms, Malad, as per the Act procurement rules, Malad, they have to maintain a register of everything, Malad, and every signature has to be taken. These are open, Malad, in our absence, Malad. That's my case, Malad.
In terms of the NIT, the tender was to be considered by the bid system. And the tender was to be open on
Para 7 and 9,
the
everything.
petitioner now submits their option, so the technical bids of the tenders were opened and the petitioner qualified the technical bid stage. He says that no.
They ought to have acted in a transparent manner, Malad, calling everyone, Malad. That's a requirement of law, Malad. If they can show that we have signed, Malad, well, the financial bids were open, Malad, in the paper, Malad.
Lordship, this is the price bid, Lordship, of the petitioner.
Price bid of the petitioner.
Petitioner, Lordship. But it's a manipulation, Lordship.
No, my bid has not been manipulated, Malad.
No, what he's saying is
My
that
bid
All
has not
bids
been
are
manipulated.
before, Lordship.
Well,
All bids are
I'm
before.
saying,
all the bids are here.
All are bids.
Malad,
Okay, now let me see the respondent
Yes,
number
sir.
5. What is his name?
Bharat Gogoi.
Bharat Gogoi, Malad.
Lordship,
Bharat
from the
Gogoi.
record, Lordship, I have seen no notice has been served on Bharat Gogoi.
No, we have 30% in the justice service, Malad.
Let me see Bharat Gogoi if
Maybe
there's any
justice service.
manipulation.
And we filed an affidavit to the effect also.
But Bharat Gogoi has not received, I have checked.
He, what he has
I
not
have
received.
checked, I have checked. The record. In affidavit, you have.
How can you see the board record?
No, affidavit, can I not say, in the whole thing? There is nothing. There's a flag mark in a Bharat Gogoi. The price bid is there, both technical and price bid.
Malad, first question, Malad, is whether, Malad, we were present on the day when the financial bids were opened, Malad. That's the first thing that we've seen, Malad. If I was not present, Malad, how could they have opened it, Malad? That's the first violation, Malad.
Let the first allegation on the oath that manipulated.
No. First
Whether there is
allegation, Malad,
manipulation
first
or not.
allegation is, Malad, that we were not asked to be present, Malad. That's the first allegation, and therefore, Malad, I applaud manipulation, Malad. My learned friend, Malad, is, Malad, trying to put this, Malad, cart before the horse, Malad. It's not that, Malad.
I am not that type of practicing like you.
No, I'm saying, I'm talking about the submission you are making, that I have made the one allegation. The first allegation is that it was manipulated. The first
These are-
allegation is that, Malad.
These are
First
core
allegation is,
issues,
Malad, first allegation is, Malad, that we were not called for, Malad. That's the first allegation.
Even if not called Lordship, how next is defined Lordship? If there is
Next,
no
Malad,
manipulation.
they have to be transparent, Malad. And that's a requirement, Malad.
3,37,000 with work Lordship for to be completed only 1 month Lordship.
Why, Malad, they could not call everyone for the financial bids, Malad?
Who is this other person? This one is
Bharat Gogoi Lordship can speak.
Konwar. Powar.
Honor, he is the petitioner. He is the proprietor of Apal Electronics.
Powar had quoted 3,60,000.
Aruna Kumar Lordship, 3,60,000.
Same as
10%.
same as the respond number 5.
Lordship.
And why he has not been considered, that minus lordship would find lordship. Now, in other file, right, lordship,
Another file.
another file, lordship. There is a minus lordship.
Let's have it.
And there is comparative statement is also lordship. So far, decision number 641, all bidder has reported 10% below lordship. That is the minus lordship. He has not completed lordship earlier work lordship. That's why. And I have checked mark all that his document.
Opal Informatics.
Yes, lordship.
Yes. Now what to do?
My lord, as per the Assam procurement rules, my lord, Assam public procurement rules 2020, my lord. When the bid is open, my lord, the financial bid as well as the technical bid, my lord, it has to be, my lord, all the bidders will be there and their signatures will be taken. That's the first requirement because my lord, lordship is looking into lordship is will look into only the process, whether there is a transparent process or not. My lord. Utmost transparency is to be maintained, my lord, while finalizing the bids, my lord. Now here, our case is, my lord, no notice was given when the financial technical bid was open in the tender itself. The 25 Ward 2024, my lord, the financial bids, technical bids will open. My lord. We are present there, my lord. We are not making an election on that, my lord. But, my lord, thereafter, no information was given as to when the financial bid would be open, my lord. It was open. And it was, my lord, our case is that it was open on second, my lord, when we were absent, my lord. In our absence, it was open. That is the reason, my lord, we are apprehending, my lord, manipulation, my lord.
But 5 bidder will appear lordship, page 9 lordship.
So records will reveal whether our signatures were taken. That much I'm not at this stage.
He should not to appear. What we can do, lordship?
Let him know that information was given to us, my lord.
He was informed telephonically. You have the telephonic record on. If necessary, lordship, we can file affidavit also.
Look, the work is to be finished in 30 days, my lord.
Then Nuchid also in that respect, lordship. As lordship, MCC is coming, lordship. That's why all are up to.
There is a question of giving telephonic information, my lord. In the entire process.
Five bidder were open. Even in his absence, lordship, it does not make any difference, lordship. There is no malafide on the part of. It's a very small amount, 3,37,000.
That's the reason I'm alleging malafide, my lord, because they ought to maintain transparency. They're responsible to maintain transparency, my lord.
At the same time, petitioner should come.
They must have a procurement register, my lord. Is that, my lord?
How many persons took part?
Lordship, in this bidder, 3 persons.
Three.
3 lordship.
Who was it?
Lordship, one is Arunabh Kaur, one is Bharat Gogoi, one is Ankur Kaur. Ankur Kaur is Opal election. That lordship, comparative statement, lordship, there's those sections to be.
Procurement useful.
Lordship can find that comparative statement also.
Opal, there are 4 bidders out here.
No, lordship, it is in defined work, lordship. Construction of RCC slab over existing drain at ward number 7 and 9 of Amgoi town. There are many, several bids were open on that day.
Which one?
I think we'll take it up on another date.
Well, the work will be finished. That's the difficult thing. Otherwise, my lord, I would not, my lord, definitely not press for it, my lord.
Now what is to be done then?
My lord, if they have not maintained transparency, lordship will interfere, my lord, let's stay the work, my lord. Because they were supposed to maintain the transparency, my lord. Whatever small work, big work, doesn't matter, my lord. In tandem matters, lordship's powers, lordship will interfere only with the malafide or if the transparency has not been maintained, my lord. As per the procurement rules, my lord, it has to be very in a transparent manner, things will be done, my lord. here what they have happened.
But then you have also not completed the work order earlier with the bill. It says here, contractor of all informatics has not completed the previous work allotted to him 8 months ago.
The notice was issued to him, that notice is also in the record.
That of course instruction I don't have. Man.
Yeah, because if that is the case, then there is a justification for not giving it to you.
Maybe that will be a different issue, of course, man. But then otherwise, man, so far as with our case is that we were not called for the Miller process. I mean, otherwise, they would have rejected me in the technical bid itself, my lord. Why they called me in the financial bid, my lord? If that was the case, my lord, they would have rejected me in the financial bid, the technical bid itself, my lord. That was their responsibility, my lord. If I had not completed the work, my lord, my technical bid it wouldn't have qualified. It's in the financial bid.
But then they can do it at this stage also. There's no.
They can do, my lord, but then they could have done it then there, my lord. In technical bid, my lord, they did not raise an objection, my lord. I was qualified.
No, technical bid. You see, technical bid only is to the effect that whether the technical aspect of it is sound or not. The question whether you had not completed the earlier contract work
My lord.
can be taken at any time, even after opening the financial bid. It doesn't have to be at the time of technical.
But then, my lord, since in the technical bid, my lord, basically the issue is whether I have the competence to do the work. Apart from the technicalities, my lord, this competence will also be reflected, my lord, whether I have completed my earlier work or not, my lord. See, if I had not completed my earlier work, my lord, they would.
No, but then supposing they have overlooked that aspect. There's no bar for them to look at it after opening the financial bid.
Well, of course, I don't have any instruction on that, my lord, but then my submission is, my lord, they ought to have, my lord, rejected it then there, my lord. And, my lord,
That's one way of looking at it.
procedure has not been followed.
Because I don't know, with the various Supreme Court judgments, they are in a very weak wicket. Only thing is that, why didn't you inform them about when the financial bid was going to be opened?
Lordship, to have my instruction, Lordship, as the MCC is coming, Lordship, that I'm going municipal board is also in a hurry, Lordship, in completion of those works before the summer is coming, Lordship. Anyway, Lordship, but other 5 were appeared, Lordship. Attended.
5?
Other 5 bidders also attended, Lordship.
You said there are only 3 bidders
No,
now.
there are total 4 bids were open. Total altogether 8 bidders, Lordship, were participated in all projects. And bidder in all that project, Lordship, 4 projects. Total 8 or 9, Lordship, I forgot to say, verified, Lordship. They have participated. Out of that, 5 were present, Lordship, while opening that bid, Lordship. That signature is there, Lordship.
Those are in different projects, man. There are 4 works, man. There are 4 works under the same. There are 4 works.
Open together, Lordship.
That's a different issue, man. But there are 4 works, man. I participated in 2. One is in this case, man. Other is in the second matter, man. My specific cases, I was not even called for the financial fee when the financial breach happened. That's my specific case, man. And that's the reason I apprehend manipulation. Man. That's my case.
But
therefore, here, my lord, what they're saying, they're in a hurry, my lord. But they were in a hurry, my lord. They couldn't have called me, my lord. I mean, that's that explanation, my lord. I don't understand, my lord. They were in so much of hurry that they could not call me, my lord. One of the tenderers, my lord. How can that be an explanation, my lord? What was the hurry, my lord, that they could not call me, my lord? It was just a one letter, my lord. They could have posted to me, my lord. A mail they could have posted to me, my lord. Nothing of the sort, my lord. They're saying that they were in a hurry, my lord. They couldn't have posted. They didn't have the time to, my lord, post a letter to me, my lord. That itself shows, my lord, that their intentions are not proper, my lord. It may be small work, big work, doesn't matter, my lord. They have to, my lord, maintain transparency, my lord. As per the procurement rules, my lord, give the details, my lord.
Any citations in your favor?
A citation, my lord. Well, citation, of course, my lord. Lord, this is a very recent judgment, my lord. I'll just rely just on one paragraph, my lord, small paragraph, 24.2, my lord. A requirement of law, my lord, about, my lord, 3-4 lines from the paragraph 22, my lord, page, my lord.
22, my lord. The last but the penultimate page, my lord. 24.2, my lord. About second paragraph, my lord, 24.2, that paragraph, my lord. About 3-4 lines from the bottom of that paragraph. My lord. Only requirement of law for such process of decision making by the tender implementing authority that it should not be suffering from illegality, irrationality, malafide, perversity, or procedural impropriety. That procedural impropriety is there. My lord. So in a tender frame,
But the other judgments of the Supreme Court,
my lord.
which make it virtually, I mean, makes it very possible for this court to interfere in contract matters.
Yes, well, lordship should interfere in contract matters only where there is irregularity, procedural irregularity. Otherwise, well, the lordship will not interfere in the decision making process. Here, there is a specific case, my lord, that they ought to call me for the tender. Admittedly, my lord, they don't have not been able to show anything, my lord, that they have contacted me, my lord. That comes it's on the face of the record, my lord, now then. True, my lord. In tender matters, my lord, lordships with jurisdiction, my lord, will not exercise jurisdiction, my lord. I won't say lordship jurisdiction is limited, my lord. Lordship will not my lord, exercise jurisdiction, my lord, unless there is something wrong, my lord, in the process itself. And that's what I've been alleging, my lord. It's the decision-making process, not the decision that lordship will look into, my lord. In the decision-making process, my lord, they have committed this, my lord, this lacuna, my lord.
But then there were how many persons during the opening of the financial bid?
I have not said.
Right.
Technical bid, we are informed we are there. We are not alleging anything on that, my lord.
And how many with regard to this particular? Three.
Lordship, some same tender have participated in RR bid also. That's why Lordship it's come to 5.
That's quite possible.
But Lordship might come with submission. Their apprehension because they were not invited, rightly or wrongly, Lordship. What is the apprehension? They might manipulate. But I have produced the record, Lordship. There is no manipulation.
Well, that we
So
can-
let me compare. So the very basis of this, their apprehension for not inviting, that manipulation, Lordship kindly verify. There is no manipulation.
No, well,
And
my
their
submission,
rejection is only valid ground, Lordship. So my humble submission.
my
before
my
Lordship,
submission.
Lordship, there are-
Good.
So my humble submission before Lordship, this matter, Lordship may not interfere in this case. And moreover, Lordship, the private respondent in whose favor that award he was given, Lordship, Bharat Gogoi. He is also not before Lordship. Of course, I have checked this because I have been doubt whether he was served or not. Order apparently.
Yeah, six. Well,
And the executive officer, he was added as a respondent by name, but without erasing any malafide or Lordship in personal level. Whatever he done in his official capacity.
Yeah, for the
Respondent 4,
municipal
principal authority.
4, 5, 6.
No, only 4. 4 is the municipal board. I'm going municipal board. 5 is by name he has made, but I cannot appear.
Work has been, what is the status of the work?
Nearing completion. I have just taken a WhatsApp communication. Plus within 1 week it will be completed.
Within?
Within 1 week it will be completed. Just I have received an
let the money be stopped, man.
Any
The
Lordship,
payment be
suppose
stopped.
they have succeeded that it is illegal, they will get compensation. They may what more than that, Lordship.
Then let them
So
stop.
at the behest of private interest, our public interest would be Lordship suffered, Lordship.
Why should development work be stalled?
Yes, Lordship.
Well, in that case,
At
well,
the behest of some public, private interest, Lordship, and no, public may not be suffered, Lordship. This is my humble submission.
my submission will be let payment be stopped to the private party respondent. Private party respondent has received the notice. He has not appeared. Bother to appear. And Well, there is an order of this honorable court, my lord, that this services will not affected, my lord. Now, having said that, my lord, since he has not bothered to appear, my lord, what affects my learned friend, my lord? He wants his work to be completed. Let the work be completed, my lord. Let the payment be to the private party be stopped, my lord. My lordship will stay.
There is no signature of the private lieutenant.
His wife has received it.
No, the wife has seen it.
There is an order.
How can you prove that she is the wife?
My lord, what kind of submission my learned friend is making, my lord?
What kind of
Under the
submission I am
CPC, my lord, any adult member can be served, my lord.
How can I expect this sort of submission from you like?
Has he challenged it, my lord? Has he said, my lord, that I have not received the notice, my lord? Somebody at home has received it, my lord. It has been accepted by this honorable court.
It is the court process, I have nothing to say.
That has been accepted by the honorable court, my lord. On 23/2024, my lord, it has been accepted, my lord. What my learned friend is submitting, my lord, how can you prove that he is his wife, my lord? Why he is making submission on behalf of the other person, my lord? The person who is not before your lordship, my lord, he is making a submission on his behalf, my lord. He is defending the board. I can understand, my lord. Under CPC, my lord, any adult member can be served, my lord.
Okay, this is with regard to this case.
Nothing.
42, na?
That's 40. 40 are similar allegations, my lord.
Huh?
But 40
Forty,
allegations, similar, but
what happened, 40 in.
I cannot do two cases, Mr. Counsel.
exactly the same case, my lord.
Lordship, 40.
Allegations exactly the same.
Maybe I don't have time.
Lordship, in next case, Lordship, private respondent, one Montu Hazarika was added as a private respondent, but he was not allotted the work, Lordship.
Acha.
In next case, Lordship, the respondent was Montu Hazarika, but he was not awarded the contract. One Kishanu Bhuya was awarded the contract.
Anyway, what to do with this item thing? Item 42.
Monday.
Monday is too many.
Or Tuesday, my lord.
We have packed. We have got full bench, we have got this bench, we have got lot of.
Otherwise, I'm not saying that because since the work is made out of short notice. Since the work is to be completed in 30 days, man, that's the reason, man.
All your cases, not, you see, yours maybe 30 days. Then tender has to be allotted within 2 days. Work order has to be issued day after tomorrow.
No, I understand.
Everything is urgent.
I understand that.
Huh?
Payments at this moment may not be released, man. That much only, my lord.
No, we're not going to go on that. Okay, we'll dispose it off in the court. I can dispose it off during the weekend. No
Lordship has
problem.
only heard it. Lordship can dispose it off. The records are before Lordship, man.
Yeah. All right.
Well, so far as the other cases, just make it small submission.
Wait. One at a time.
Man.
Item 42. Third, Mr.
And that's it.
The M data and counsel for the petitioner. Also had Mr. P data. PP data for
That's one of four.
paper number 4. Miss A. Das. You that. 120. Anything? So which one? Both the files are important.
First one is decision of minutes, Lordship. Second one is the bids, Lordship, bid document.
Okay.
Lordship would find a comparative shape in the first file, smaller one.
That's it.
Hearing concluded. They have been reserved, huh?
Right.
And then this, we'll dispose this up. You'll take this. And this also will come here in this one. Is it? Okay, then give me the next case. Yes, what about here?
43.
How will you change the record? I'll see.
My only submission is that my learned friend said the person who made a party, my lord, he was not allowed the work. In fact, he was allotted the work. This Kishanu Bhuya, who has been subsequently allotted the work, he was earlier rejected. I don't know how he made a representation, my lord, asking my lord that why his case was his tender was rejected.
No. Tell me, okay, who is this respondent number 5?
My lord,
He's got nothing to do. 6 is Montu Hazarika.
He was not allotted.
Not allotted.
This is the Kishanu Bhuya one who was allotted.
in fact, my lord,
In the first file, Lordship, that allotment letter is there. It's small one. And the
So this writ petition is of no use.
Well, Lordship,
Yes,
can you see
in
the,
this-
is the
in this
record,
case
in the
also,
record, my
Lordship,
lord?
Huh?
Is the
Same
record,
allegation has been alleged that manipulation of record. Lordship, I have all the 10 bit document, Lordship. First bit of the petitioner as well as other, no manipulation, not a single mark, Lordship.
my lord, so far as manipulation is concerned, my lord, since I was not there, my lord, they could have easily changed the tender of other people.
Now you
That
can
is-
see, you
that
can
is
see
there, my
if
lord.
there is manipulation or whatever.
That will not be evident from the record, my lord. The basic case is, my lord, that I was not called for. My lord, in this case, my lord, this Kisanu Bhuya, my lord, he lodged a complaint, my lord. Lordship will kindly see whether.
No, just tell me one thing. This Montour Hazarika, now, he is not the person who is doing the work. Somebody else is doing the work.
Yes, Kisanu. He is not a party, Lordship.
Huh? He's not a party.
No, no, he has not been made party in the second case.
The second case, who is the person who has been given?
One Kisanu Bhuya, Lordship.
Krishanu Bhuya.
Lordship would get his allotment order, page 12 of the first file, Lordship. Smaller one. Thin file, Lordship.
Huh?
Page 12, the allotment order,
Page 12.
12,
Of this one.
thin file.
There is no thing for it in the other one.
The other one, দাদা এই সৰু ফাইলটো দিয়কচোন অকমানি এটা পাতলাটো।
My lord, this Kisanu Bhuya, my lord, he was earlier rejected, my lord. He filed an application before the my lord, board. That may be in the part of the record, I don't know, my lord.
I don't know. That's anyway, that is a
Then
different
you have
issue.
to- then you have to implement, my lord, Kisanu Bhuya. Then.
Huh?
You have to file an implement petition.
Yes, you have to find.
That will, lordship will find it.
Huh?
Can't help me.
But why should you? Why you have to file a separate writ petition?
12
against him.
No, my lord, impleading, my lord, impleading him, my lord. Because the basic allegation remains the same, my lord. We are not called for the tender process.
This also will dispose of. But both hearing concluded judgment is both.
Page 7 and 8 is the Lordship comparative statement and page 12 is the Sanofian.
Huh?
Page 7 and 12 is the comparative.
Page 7 and
12. Page 7 and page 8 are the comparative statement of
page
both the
7 and 8.
7 and 8 are comparative statement of both the works in respect of 641 and 662 repetition. Page 8, 7, Lordship, in respect of repetition number 641.
Huh?
Page 7, Lordship,
Yes.
7 of the is the comparative statement in respect
Page
of
7 of what? Of the writ petition?
no, no,
Of
in my
what?
record, Lordship.
Record, say
Record.
that.
That not that the Lordship, this one, Lordship.
Thin one.
The thin one, Lordship.
Page 7.
Page 7, Lordship.
Pagination to.
That those, yes, Lordship.
Okay.
Page 7.
Yes.
It is in respect of construction of RCC slab of our existing drain, ward number 7 and 8, repetition number 641,
Where are you reading? Page 7.
page 7,
Oh, yes.
yes. It is in
No, Opal, informatics was here also.
here also, yeah, and there also,
So outrage has been given to?
and page 9, Lordship.
No, outrage has been given to whom?
In Lordship,
At page 7, there's no Krishna.
no, Lordship. Page 7, there was, in that case, Lordship, it was awarded to one, Montu Hazari. No, he is a 90. Page 641, no? The Bharat Gogoi, Lordship.
Huh?
Bharat Gogoi.
What Bharat?
Bharat Gogoi, page 7.
Yes, sir, you told me that Krishna, I've written it also.
Lordship, it is in respect of 662. Montu Hazarika is in respect of 662. 43. Item number 42.
In this,
Lordship,
no, you are too confusing.
item 42.
You
Lordship,
see, I have written it down also.
yes, sir.
His
Item
name.
item
It is, this is in respect of 662.
662.
Now, where is the comparative statement for 662?
Lordship, page, Lordship would get comparative statement, page,
Okay, this item 43, is it? List
Page
the
eight.
matter,
Page
list the
eight.
matter after the week. Next, no more. I've had enough. As it is, I'm not well and I'm listening to yours. Yes, next.
Yep.
Chalo. Yes,
May be the lordship. In this case, lordship, we have served justice service and thereafter affidavit also filed, lordship, upon
what do you want out here?
Lordship,
What is your prayer out here?
lordship, reconstruction of the tenanted premises, lordship.
Reconstruction.
Yes, lordship. So lordship, may I pray it is to be fixed on 21/3, lordship.
That item 42 also you listed next week. Don't say CAB. 42 also both. No CAB. Next week. Yes, what about this? What do you want?
46, lordship, service complete, matter may come for admission hearing on 21/3, lordship, my only prayer is. 21/3 only, lordship, the reconstruction of the tenanted premises, lordship.
Okay. Yes, madam. I think everything is in her favor. That's the
Lordship.
RSA is also in her favor.
And moreover, lordship, they have received notice on 19.
Is there any private respondents out here? No.
Private respondent in the RSA, lordship, but their house, they were also not.
No,
allowed.
out here in this department.
No, lordship. Only me, I have grievance with.
So what is your prayer out here? Your prayer is that
My prayer, lordship,
you should be allowed to reconstruct the.
yes, lordship.
You should be allowed to reconstruct
Along
the.
with the entire Chowk Bazaar, lordship tenants, lordship. Only.
Others have been allowed to reconstruct.
Others all allowed, only plaintiff and defendant, we both were fighting before this court. So our two shops were not allowed. lordship.
Not allowed to be reconstructed.
Reconstructed.
154.
It's acha.
154.
154 and 154A.
Yes, lordship. After, up to RSL lordship, we both lordship were allowed 154A and 154. So now only permission to be given for reconstruction, lordship.
Yes.
Lordship,
So municipal code is
municipal
required.
board is the main party, madam.
Who is for the
Just
municipal
for
board?
municipal
They
board.
received notice on 19/2, lordship.
Right.
Yes.
Miss R. Chowdhury appears for the petitioner, while Miss U. Das appears for the
1 and 2.
respondent number 1 and 2. No one appears for the Tezpur Municipal Board.
Justice service served, lordship.
Good stuff. However, the affidavit of service filed by the petitioner shows that notice has been served upon the respondent number 3
Page
by way
9,
of dusty service on 19/2/2024. Accordingly, notice deemed to be served upon the respondent number 3. Full stop. In the interest of justice and to enable the respondent number 3 to appear on the next date, comma, list the matter on 21st. Full stop. It is noticed that that this court in its judgment dated 21/7/2023 passed in RSA 105/2019
Has already uphold the decision of the.
the decisions of the trial court and the first appellate court have been upheld. Thereby, no, full stop. Therefore, it appears that there is no justification not to allow the petitioner to reconstruct her portion of the shop. That is shop number 154A. List the matter on 21st. So one chance we'll give them to appear.
Lord, 21st Street. Lord.
After High Court order, madam, there is nothing.
There's nothing left.
No,
There's nothing left now.
I'm deeply.
But one chance only there for Namka Vaste Sever.
Lordship.
Well, can I prefer dating 14/14? That's a date.
You someday.
Madam.